For reasons mentioned in the order, the petitioners are allowed to go on bail of rupees 1 lakh each with certain conditions.
No. I'm deeply obliged.
With two sureties of like.
No.
May I please also?
Yes.
Also, I'd like to mention for listing of one bail application on tomorrow also.
Listing, no mentioning for listing. Whole week is mentioned. Whole week is
It was
motion.
filed on Friday also.
What is the matter?
There was a deed of agreement between the accused and the complainant.
What is the offense?
Offense was 420-406-379.
Okay. Okay, yes, allowed.
Yes.
May I please, your lordship? I beg to mention for listing of a matter on orders, lordship, for orders.
What matter?
This is a criminal revision petition being filed by I am on behalf of the informant, respondent number 2, lordship.
Why you are mentioning before this?
Because the POXO matter is being stayed by this honorable court, and the victim and the informant wants that the matter to be expedited. This is the reason. Last time when the matter came in, they mentioned without taking our consent, they mentioned before the court.
But then you have to mention before senior courts because other.
Yesterday we tried there, but it was referred to this honorable court. This is the reason. But yesterday when we reached, it was late. Mention hours were over. Yesterday we tried in 22 as well as in 21.
Yes.
So both the benches they had referred for this honorable bench.
When do you want?
Any date convenient for lordship before vacation. Any date.
Tomorrow.
Yes,
Day
lordship.
after tomorrow.
Day after tomorrow? Yes, lordship. Deeply obliged, lordship.
May I please, your lordship? But I beg to mention item number 60, my lord, supplementary. On behalf of S. Munir, my lord. But this is a commercial quantity matter, my lord, and the trial court, my lord, 1st of July date is fixed, my lord. So, my lord, immediately after vacation, my lord, the matter may be fixed, my lord. Commercial quantity, my lord. And 18th of July, it is possible, my lord.
On request of learned counsel for the petitioner, let this matter be listed.
18, my lord.
On 25th July. 18 we have cases. 25th July.
Oh, may I please, your lordship? Lordship, I am praying for listing of anticipatory bail, my lord. For tomorrow or day after tomorrow, my lord.
No mentioning. In whole week is motion week.
My lord, your lordship has granted bail to another co-accused, my lord.
In the
That's
same
why
case,
I'm mentioning this month, my lord.
day after tomorrow.
Obliged.
May I please, your lordship? I'd like to mention item number 16, 17, 18, 19 of today's list, your admission list, your lordship. Kindly matter be taken after vacation, your lordship. I've taken the concern from the other side, your lordship.
You are for the,
Petitioner, your lordship.
what's your name?
S. Nazneen.
Heard Miss S. Nazneen, learned counsel for the petitioner, who prays for an adjournment with the consent of the counsel for the respondent side. Considering the submission, the prayer is allowed. Let this matter be listed after summer vacation.
After vacation. Deeply obliged.
May it please, your lordship? I'd like to mention item number 61, bail matter. Kindly matter may be taken after 2, your lordship. 61.
Why? What is your name?
A.B. Datta, your lordship.
Dr. Learned Counsel for the petitioner, who prays for an adjournment. Stop. Prayer is allowed. Let this matter be listed after vacation.
May I please, your lordship? I beg to mention item number 23, lordship. Lordship, this matter is in trial court, is in argument stage, lordship. So we want to close the matter, lordship.
What do you want? What is the
Close
prayer?
Matter, Lordship.
Withdraw.
Yes,
You want to withdraw?
yes, Lordship.
What is your name?
S. Begum.
S,
Begum.
but your name is not there.
There is my name, Lordship.
On
S.
whose
Begum.
behalf you are submitting?
S.K. Nargis, Lordship.
Heard Miss S. Pegu submitting on behalf of Miss S. K. Nargis, who prays for allowing the petitioner to withdraw the instant bail application. Considering the submissions, the prayer is allowed. This bail application is dismissed on withdrawal.
May it please the Lordship, Lordship, I beg to mention item number 25, Lordship. Lordship, matter may be taken off after vacation, Lordship. There's some difficulty today.
Third, Miss N. Dekaraja, who submits, who prays for an adjournment on the ground of personal difficulty. Let this matter be listed after vacation.
Lordship, kindly fix a date, Lordship.
Registry to, on a date to be fixed by registry.
Much obliged.
May I please, Lord, I beg to mention item number 63, my lord. 63 from supplementary list, my lord. This matter will be taken as the last item, my lord.
63.
Yes, my lord. As the last item, my lord, kindly, my lord.
63
Before rising,
63 is otherwise in the
my lord.
last.
Yes, that's why this is also the last, my lord. So can it be before rising, my lord, at 4:30?
No, if it reaches, we will take it up.
My lord, can it be at 4:30, my lord? It
No.
will take only 5 minutes, my lord.
No, we'll go in serial.
My
We'll
lord,
try to reach.
my lord.
May
Oh, bless, my lord.
I like to mention item number 41, Lordship, for withdrawal, Lordship.
Yes. 40, what is the prayer?
So I want to withdraw this case, Lordship. 41, Lordship. So this was AB, Lordship, but during the pendency of this case, accused
He was
person already arrested, Lordship.
Heard Mr.
AK Azad.
A.K. Azad, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application, anticipated bail application, as the petitioner has already been arrested. Considering the submissions made by learned counsel, this bail application, this anticipated bail application is dismissed on being infructuous.
Most.
My lord, I'm sorry, my lord, item number 60, my lord has fixed the matter on 25th, my lord. Can it be on 23rd, my lord? 25th, my lord, council will be out of state.
Okay. 56,
60,
item number 60 on
23rd.
23rd.
Much obliged.
May I please, your lordship. Item number 61, it was mentioned, my lordship, for upgrading at 2, my lordship. But it was,
No upgradation.
so it may be taken at usual course, my lordship.
It will be taken up. Mm. 61 has been mentioned,
Yes,
an adjournment has been,
no, my lordship, it was mentioned for upgradation, my lordship, at 2.
no, who mentioned?
Our
Who is
chambermaid,
Abhi Datta?
our chambermaid only. my
Call him.
lordship.
If he comes, I'll change it.
Okay, my lordship.
May please, your Lordship. My lord, in this case, we have taken steps long back, Lordship. FIR, Lordship, will find at page 10, allegation under section.
Whether notices
No,
on respondent number 2 has,
we have taken steps, Lordship. Office notice there, Lordship.
Lordship, service report not received. I have to verify.
Already
you have
64
taken steps as per the
notification. Lordship.
notification.
Yes, Lordship.
Then you take instructions from the OC whether,
Already 64 days in custody. Lordship.
what tell you. Investigation is going on.
Yes, Lordship,
on-
case
on
is
check.
pending.
Is
Day
it a
after
cha-
tomorrow,
is it a
Lordship.
charge sheeted case or
No, Lordship.
whether case diary has arrived?
No, Lordship. Motion stage, Lordship.
No, it should have come up for hearing, Lordship. It was listed for motion on 13/6, Lordship.
Case diary was not called for.
Case diary was called and notice was issued, Lordship.
No, there is no order for case diary. Only notice,
Then Lordship may call for the case diary.
because unless case diary arrives. We are calling for the case diary.
Lordship, 64 days in custody, it's short date will be given, Lordship.
From
After
Hussain.
vacation,
On
Ah.
15th,
on reopening,
reopening day.
heard Mr. M.I. Hussain, learned counsel for the petitioner, also heard Ms. N. Das, learned additional public prosecutor. From the office note dated 18/6/2024, it appears that the petitioner has taken steps for issuance of notice on respondent number 2. Learned additional public prosecutor is requested to take in information from the officer in charge of Murajhar Police Station, in Hojai district, as regards service of notice on respondent number 2, and let this court know about the fate of such notice on the next date fixed. Also call for the case diary, as perusal of the case diary would be necessary for consideration of the instant bail application. Let this case be listed again on 15th of July. 15th July.
Obliged. Lordship, in this case also, CD was called and notice is issued. Accordingly, we have taken steps on 13/6.
Same prayer, Lordship.
Here also, case diary was not called for. Heard Mr. M.I. Hussain, same order.
Lordship.
Same order, the police station would be same police station or different?
Police station is Lordship, Bosishta PS.
Police station instead of Murajhar. Officer in charge of. Officer in charge of Bosishta Police Station. Instead of Murajhar, Bosishta Dibuli. Same date.
Obliged.
Yeah, please, Your Lordship. Lordship, petitioner was arrested on 9/6/2024, my lord. FIR is at page number 11, my lord. Page number 11, in connection of which, my lord, I am arrested, my lord. So long FIR, my lord, the gist of the FIR is that, my lord, I made an agreement,
When you were arrested,
my lord, 9/6.
why the prayer was rejected by the
My lord.
magistrate's court? You,
During investigation, sufficient evidence have been found against the accused person.
Where
My
is-
lord, kindly see, my
where
lord.
is the rejection order?
Has produced some.
My lord,
documentation
page number 40, my lord. 10/6/2021, the date of production, my lord, it was rejected, my lord.
Case diary would be
My
required.
my lord,
Yes, Lord.
I have also filed an FIR, my lord. This is a dispute between
Let-
landlord and tenant, my lord.
Let the case diary come.
Both the landlord and tenant
What
are
is your
in
name?
custody.
Hi Rahman.
My lord, yes, Rana.
Heard Mr. S. Rana, learned counsel for the petitioner, also heard Ms. N. Das, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of instant bail application, hence call for the case diary. Fixing 15/7 for
Obliged.
CD on Lordship.
15/7.
Let 439 application is arrested on 29/5. 354B and 10/12 of POCSO.
12 of POCSO,
Yes, sir.
notice for shell.
May please, Lordship, the 439 application. All for the CD, Lordship.
Heard Mr.
Short
N.
date.
Ahmed, learned counsel for the petitioner. Also heard Miss N. Das. All for the case diary.
The noon muddy, Lordship.
15-7 for case diary.
This item number 7, Lordship, the same date, Lordship, all for the city. The Pan Bazaar,
Item number 7, same order.
deeply Lordship.
Wait, please, your lordship. My lord, in this matter, I am behind the bar for last 1 year, 7 months, 20 days.
1 year,
7 months, 20 days, my lord.
charge sheeted case.
Charge sheeted case, my lord, and 4 prosecution witnesses were examined in this matter, my lord.
Scan copy of the case
Scan
record.
copy.
My lord, one thing I say, my lordship has considered the bail of co-accused, my lord. And he was granted bail on 26, 2024.
No, but how he is acquitted?
My lord,
The-
on the ground of delay in culmination of trial, my lord.
But his matter has to be looked into. We are calling for scan copy. This heard Mr. M. A. Chaudhary, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. Perusal of the scan copy of special NDPS case number 158/2022 would be necessary for consideration of the instant bail application. You are praying
On the ground of delay, my lord.
only on the ground of delay.
Yes, yes. The lordship finally have a
Then in the,
case diary and
then
record.
we will call for the status report only.
And otherwise, my lord, if lordship take the records of bail application number 974 of 2024, which was disposed of last week, my lord, that would probably serve the purpose. Because that was very recent, my lord. Lordship was granted in bail on 26, 2024, my lord. May I just read the
970 of
974 of the 2024, my lord,
974.
bail application.
ये लिख लेगा, okay? No. Perusal of this scan copy of the special NDPS case number 158/2022 would be necessary in this case. Learned counsel for the petitioner has submitted that in bail filed by one of the co-accused was disposed of by this court on
26, 2024.
26, 2024 in bail application number 974
Of 20.
of 24,
Yes.
24, where the scan copy is available. Hence, praise for calling for the record of the said bail application. The prayer is allowed. Let the case record of bail application numbers 974/24 disposed of on 26, 2024 be tagged with this bail application by the registry. Let also an up-to-date status report be called for from the trial court. Let this case be listed again on 15th of July. Is it okay? 15?
Friday, if possible.
No, Friday is not possible.
Okay.
15 July 2000.
I'm with you on this.
May I please your lordship, my lord? May I please your lordship? my lord? So here, my lord, the petitioner has been shown arrested, my lord. What should we kindly see, my lord, one thing, my lord? This is the second FIR on the same subject matter, my lord. The FIR is a page 18, my lord, typed
No,
copy.
whether case diary would be required.
It will be required, my lord, but I will only show my lordship two things, my lord. First, FIR was filed at Nota Hill Station, my lord. Not
No,
first.
let us call for the case diary. On next date, we'll hear you.
Yes, my lord. I'm paying for a shorter date, my lord. On 27th or
27 would be difficult.
he's already had on 31st of March, he has undergone a heart surgery, my lord. And lordship, can you see one thing? my lord?
Which is the police station?
Jalukbari.
Jalukbari, my lord.
On 28th, lordship.
28. Okay, heard Mr. N. Mahajan. learned counsel for the petitioner, also heard Ms. N. Das, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence call for the case diary fixing 28/6/2024 for case diary. 28.
27, Lordship. Yes.
27.
indicated.
27. Obligation, highly obliged.
May I please, Your Lordship?
No.
Okay, this is a 401 criminal revision under section 401 review section 397 Lordship.
Where is the impugned order?
Impugnated page 58 Lordship. So, Lordship, there are two aspects in this case. One is that marriage between the parties but mutually dissolved by an order of the division bench of this honorable court. And on that case, Lordship, the wife
Where is the
voluntarily-
impugned order?
at page 58 Lordship.
What is the order?
Initially, Lordship, I was acquitted from the offence under section 494 IPC for the offence of bigamy, Lordship. They have preferred an appeal before a learned additional session judge, and appeal like a acquittal. And learned session judge demanded back the matter by invoking section 391 to take additional evidence, Lordship, to one Hema Konikar, when she is no way connected in this case, Lordship,
You are against that order? of-
against the order, Lordship.
No, then where is that impugned order?
Impugnated page 58, Lordship. The long judgment.
No, you are not against the judgment. You are against the order only.
No, I am against the impugned judgment, Lordship, or remanding back the matter to the learned trial court. At page 60, it starts from page 60, Lordship. Initially, I was acquitted from the offence under section 494. Lordship. Operative portion starts from page 73, Lordship. Internal paragraph 37.
Okay, we are issuing notice.
Lordship.
Issuing notice. What is your ground?
My ground is that, Lordship, because the complainant did not make any endeavor, Lordship, to call for the witness, Hema Konikar. Because there is a settled position, Lordship, 391 CRPC cannot be invoked to fill up the lacuna, Lordship. The learned session judge, appellate court, has remanded back the matter to fill up the lacuna by the complainant, Lordship, a CR case, Lordship. Because in the trial court, complainant has examined as many as 8 witnesses, exhibited 15 documents, Lordship, but they did not make any endeavor to call for the witness, Hema Konikar, Lordship. The learned session judge remanded back the matter to call Hema Konikar as a court witness, Lordship, only to fill up the lacuna in the case. And the trial court, Lordship, and the complainant did not able to prove the marriage, the second marriage, by any evidence, Lordship. And there should be an application under section 391, Lordship, for taking additional evidence. So without that application, learned appellate court invoking the section with the own motion, Lordship, and remanded back the matter to fresh file, Lordship. There should be an application to take further evidence, Lordship, for additional evidence. So there is no application, Lordship.
Where is the revision petition?
Lordship,
You have,
my ground at page 6, Lordship. Ground 4, Lordship, for that the learned court below committed jurisdictional error by directing the trial court to summon Hema Konikar as court witness by invoking power under section 311 CRPC.
heard Mr. What is your name?
D. Kolita, Lordship.
Heard Mr. D. Kolita, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This criminal revision has been registered under section 401/397 of the Code of Criminal Procedure, 1973. On filing of the revision petition by one Pradeep Konikar, impugning the judgment and order dated 22/4/2024 passed by learned additional session judge number 2 within bracket FTC Tinsukia in criminal appeal number 02 within bracket 1/2021, whereby the judgment and order dated 21/2021 passed by learned additional chief judicial magistrate Tinsukia in CR case number 125C/2014 was set aside. And the case was remanded back to the trial court for taking additional evidence. Stop. The trial court, by its judgment dated 21/2021, had acquitted the above named petitioner under charges of offense under section 494 of the Indian Penal Code. Let the case record of criminal appeal number 2 within bracket 1/2021 be called for from the Court of Learned Additional Session Judge number 2 FTC. Let also the scan copy of the case record of CR case number 125/2014 be called for from the Court of Learned Additional Chief Judicial Magistrate Tinsukia. Issue notice to the respondent. The petitioner shall take steps for issuance of notice.
Till returnable date, Lordship. Operation of this.
No. After service of notice.
Lordship, if the trial start, Lordship, this petition will be infectious, Lordship. Because
Yeah.
till returnable date, Lordship. Because the
You
marriage,
take steps.
because Lordship, my marriage between the parties had already dissolved.
What I was.
Till returnable date, Lordship.
Petitioner shall take steps for issuance of notice. When is the next date fixed?
And next week, Lordship.
When?
On
You received summons from the, after remand of the case.
not till, I have received, Lordship.
For what,
Lordship.
for what purpose the next case? The
Next
date
case is fixed for witness, Lordship, for state, Lordship, for Hema Panikar. Till returnable, Lordship. Maybe fix a date until returnable date. Operation of the MP on the state, Lordship.
No,
Because this, I was acquitted, Lordship. If trial start, Lordship, this petition will be infectious. If I was convicted, Lordship, I have to file an appeal, Lordship, and this petition will be infectious in that case, Lordship. Because there's only one witness has to be examined.
let this fixing,
A date may be fixed, and till that, operation of the MP on the state.
fixing 18 July. Fixing 18 July. The prayer for interim relief would be considered only after service of notice on the respondent.
I will be allowed to take justice service, Lordship, because the address given by the respondent one, as per my information, Lordship, she have left that place.
No, why you have not given proper address?
Lordship, as far as
You give the present address.
I have only this address, Lordship.
So where will you take justice service? If you don't know
New
the
Zealand and Eastern.
prayer for interim relief would be considered only after due service of notice on the respondent, list accordingly.
Obliged.
May it please the Lordship. By way of instant criminal petition, Lordship, the petitioner preferred this criminal petition, Lordship, for quashment of the domestic violence proceeding, Lordship, against the petitioner. Lordship may come to annexure 2, page 16, Lordship.
For quashing,
Lordship, may it please your Lordship.
Lordship, here the petitioner is praying for quashing of an FIR dated 29/4/2022. Here,
Where is the FIR?
FIR is at page 12, Lordship, Annexure 1. Lordship. The respondent number 2 was the wife of the petitioner. Lordship. And FIR has been lodged under section,
Who lost the FIR? Your wife?
wife lost the FIR. Lordship. 498.
What is the
Yeah.
ground?
Lordship, here, since the petitioner and the respondent have compromised their matter and they have agreed to withdraw, Lordship. Here, Annexure 2, Lordship. Annexure 2 is the compromise deed. They have a page 21.
No, no, what is your ground?
My ground is that since it is a matrimonial dispute, Lordship, since they have agreed to withdraw the cases filed against
Okay,
each
we are
other,
reviewing
Lordship,
this. Heard Mr.
as this amount.
S. What is the name?
As this amount.
Heard Mr. S. J. Sharma, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure 1973 has been filed by the petitioner Vallabh Das, praying for quashing of the FIR dated 29/4/2022, filed by respondent number 2 within bracket, the wife of the petitioner bracket close, on the basis of which North Guwahati PS case number 42/2022 was registered. Issue notice to the respondent number 2 and call for the case diary of North Guwahati PS case number 42/2022. Fixing 23 July. The petitioner shall take steps for issuance of notice on the respondent number 2 by registered post with Hague, returnable on 23rd July.
This may be fixed for the
23rd.
public. Lordship 438, page 14 is there. 1/4.
Yes,
Now, my lord. May I read now?
yes. What is your case?
Now, my lord, the main accused, my lord, she has already been arrested, my lord, and the arrest memo, my forwarding report, page 16, my lord. Grounds of arrest during the lordship got 1/6.
Yes.
During the investigation, course of investigation, it revealed that the fake documents which the arrested lady had submitted at SBI Haflong branch were recovered from her possession and accounting received. My lord, the petitioner is not being connected in this case.
Then why are you worried?
And now, my lord, on several occasions, police tried to apprehend me in connection with the case, my lord. Lordship, after arrest of this lady, a number of occasions approached appeared before my lord, by the police.
Arrested lady had approached,
No, the police, my lord.
police approached you
The lord.
after arrest of the
This lady.
FIR name.
My lord.
You are not involved in any.
No,
case.
I am not.
Let the city come first.
Now, my lord, this grounds of arrest specifically shows that all the fake documents which are prepared is recovered from her bag. In the last line, my lord, she has confessed one name.
Now, whether she is still in custody, she,
That
the,
lady, she apparently is still.
you
in
don't know.
My lord, she is still in custody.
Okay, let us give him the interim, let him appear.
My lord.
Heard Mr.
Yeah, lord.
J. Lusker. J. Lusker, learned counsel for the petitioner, Also heard Ms. N. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Lalren Pui Mar, who is apprehending her, she's a male or female? She's a she, her, who is apprehending her arrest in connection with Aflong PS case number 35/2024 under section 416/468/420/471 of the Indian Penal Code. The gist of the accusation in this case is that on 18/4/2024, the chief manager of State Bank of India Haflong branch had lodged an FIR before the officer in charge of Haflong police station, inter alia, alleging that one person came to the bank as an impersonator for updating the KYC details of account bearing number 1131521252 belonging to one Maya Thakuri by forging documents and presenting herself as the account holder. Stop. On receipt of the said FIR, Haflong PS case number 35/2024 was registered. Learned counsel for the petitioner has submitted that after lodging of the FIR, one Marina Patra, who was found involved in the offense, has already been arrested. Learned counsel for the petitioner has submitted that the petitioner is neither named in the FIR nor she is in any manner involved in the offense alleged in the FIR. However, the police of Haflong police station police have visited your residence?
Yes.
Police have visited her residence on several occasions, and she apprehends that she may be arrested in the aforesaid case, though she is in no way involved in this said case. It is also submitted by learned counsel for the petitioner that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has submitted that perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Stop. Call for the case diary. 22/7/24 for case diary. However, in the meanwhile, considering that documents annexed along with the bail application, including the FIR as well as the forwarding report of the arrested accused persons, there appears to be nothing against the present petitioner at this stage. Hence, the above named petitioner is directed to appear before the investigating officer of Haflong PS case number 35/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If she does so within the stipulated period of time, in the event of her arrest in connection with Haflong PS case number 35/2024. The above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one security of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 is let this case be listed again on 22nd July 2020.
I'm sorry, your lordship, item number 61 was mentioned for upgradation. There might have been misunderstanding, my lordship. Apology on our side, my lordship, may be taken up in usual course, my lordship.
Okay, in due course we will take up.
Highly obliged.
CP 11, CD 1. Lordship, item number 11, CD fixed. 22nd July.
22nd, 2/2.
Lordship, for 38 application, my lord, there are 4 petitioners before your lordship. My lord, FIR may be found at page 10. May I read, my lord?
What is the stage? Investigation stage.
Investigation is still, my lord. What happened, my lord? I have purchased a vehicle, my lord, JCB, from the informant, and the consideration was 19,01,000 rupees.
Who
And
has purchased?
I have purchased.
I means there are 4.
My lord, petitioner number 1. Sorry, my lord.
Okay.
Petitioner number 1 purchased one vehicle from the informant, and there was a deed of agreement for sale, and the consideration was 19,01,000 rupees. And as per the petitioner, my lord, he has paid all the amount. Now the informant claiming 4 lakhs more money, my lord, from the petitioner number 1, and that is the dispute, my lord. I have annexed all the money receipts, agreements, etc., my lord. My lord, kindly have a look at page 18. This is the deed of agreement.
19,000, 19 lakh, 1,000.
19 lakh 1,000 out of 19 lakh.
Is there any other co-accused who has been granted any bail?
No, all are before your lordship, my lord, except accused number 5. Other petitioners, other accused.
What happened to accused number 5?
He has filed separately, my lord.
Whether he has been granted bail or any?
No idea, my lord. Perhaps he in the district court, my lord. Yes, my lord. Now, my lord, in the deed itself, he on the day of execution of the deed, he has received 9 lakhs.
What is the name of the
Informant?
The petitioner number 5?
Shahjahan Ali.
Shahjahan Ali.
Shahjahan.
Sudeep. Welcome. EB case number 1560, dated 13/6/2024, order 2 months. Yes.
My lord, now, on the day of execution of the deed of agreement for sale, the informant received 9 lakhs, my lord. He acknowledges the amount, my lord, page 19. Per 1, my lord. Can we see?
Okay.
Lordship has seen, my lord. The value of the vehicle is fixed 19 lakhs 1,000 rupees only out of an amount of rupees, out of which an amount of rupees 9,01,000, which has been paid by the second party to the first
You were
party.
the petitioner number 1 was the purchaser.
Yes, my lord.
You purchased from Jahangir Alam.
My lord.
Okay.
Now, on the day of execution, my lord, I have paid 9,01,000. Thereafter, my lord pays 22 and 23. Kindly see, my lord, on 3/1/2024.
You have paid the money.
He received 6 lakhs.
Okay.
Thereafter, my lord, remaining 3 lakh rupees, my lord, there was a declaration, my lord, page 24. This is the declaration by the petitioner number 1 and signed by the informant also. Here, my lord, page 24, kindly see. It is hereby declared that 3 months back, one JCB bearing so and so of second party was sold to first party on consideration of rupees 19 lakhs, out of which the second party received an amount of rupees 16 lakhs from the first party. It has been issued today on 1/5/2024 that remaining rupees 3 lakh will be paid before 10/5/2024 by the first party to the second party. If the first party fails to pay rupees 3 lakhs or he creates any problem, he will be liable for punishment under law. My lord, this was the declaration. My lord, after that, my lord, I have paid the amount, my lord. The vernacular money received may be seen at page 30, my lord. And it was duly notarized, my lord. Page 30 kindly see, my lord.
Okay. So your case is you have paid the entire amount.
Yes, my lord. And my lord, after getting all money, my lord, the vehicle has been transferred in my name, my lord. My PP will assist, my lord. This is the registration certificate. It has been registered now in my name, my lord. After registration, my lord, he is demanding 4 lakh rupees, or otherwise he will take action. And this is the FIR, my lord, to harass the present petitioners, my lord.
Mr. Yes, Ms. Das, anything?
Lordship.
Mr. What is your name?
M. Ali.
Mr. M. Ali, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure from 1973 has been filed by the petitioners, namely 1, 2, 3, and 4, who are apprehending their arrest in connection with Bilasipara PS case number 122/2024. 2024 under section 120B/420/384/387 of the Indian Penal Code, corresponding to GR case number 220/2024. Learned counsel for the petitioners. No, before that, the gist of accusation in this case is that on 14/5/2024, one Azibur Rahman had lodged an FIR before the officer in charge of Bilasipara police station, inter alia, alleging that one JCB vehicle bearing registration number AS16AC 0148 was sold by the first informant to the petitioner number 1 at an consideration amount of rupees 19,01,000. And out of the said amount, the petitioner had paid an amount of rupees 9 lakh on the date of entering into, no. What is the allegation is that you have paid only, you have paid only 15 lakhs. That is the allegation. And out of the said amount, the petitioner had paid only 15,01,000 and remaining 4 lakhs are yet to be paid. So it is also alleged in the FIR that the petitioner number 1 is refusing to pay the outstanding amount and has been threatening to kill the informant and has forcefully obtained the signature of the informant on a blank paper. When you have paid this 4 lakhs?
My lord, 1 lakh rupees, for 1 lakh rupees, there is no money received, but 3 lakh rupees, my lord, I have money received. That is my lord, page 30.
When have you paid?
It was paid on 13/05/2024. And I have stated, my lord, on when the 1 lakh rupees was paid in cash, that is also I have stated, my lord. He received 1 lakh rupees on 1/5/2024, when on the day of, my lord, the deed of declaration, page 24 was executed.
Learned counsel for the petitioner has submitted that the petitioner's number 1 has already paid the entire sum of outstanding amount to the informant. And when have you paid the last month?
Last one, my lord, on 13/05/2024, my lord.
And the last installment of rupees 1 lakh has been paid in cash.
No, my lord, 1 lakh was paid on 1/5/2024, and last rupees 3 lakhs has been paid on 13/5/2024.
By what means?
By cash, and money received also there.
And on 13/5/2024, that is 1 day before lodging of the said affair, the petitioner number 1 has paid and the last remaining outstanding due of rupees 3 lakhs to the informant. And in support of his submission,
Further, my lord, the vehicle has been registered in my name.
learned counsel for the petitioner has submitted the photocopies of money receipt. You have submitted this photocopies of the money receipt bearing signatures of the first informant. Learned counsel for the petitioner has also submitted that in the meanwhile, the JCB has been registered in the name of the present petitioner. So. And against other petitioners, what are the allegations?
No allegation against
Why
the
they
other
have,
petitioner.
why they have come?
My lord, because there
Their
was
name is there.
a village vicar, and they were present, my lord. And petition number 2 and 3 is the brother and father of the petitioner number 1. That's why, my lord, they have been implicated. And Sattar Ali, my lord, he attended the village vicar.
It is also submitted by learned counsel for the petitioner that the names of other accused persons are mentioned in the affair. Though the dispute was between petitioner number 1 and the first informant. It is also submitted by learned counsel for the petitioner that the petitioners are ready to cooperate in the investigation. On the other hand, learned additional public prosecutor, learned counsel for the petitioner has also submitted. You don't know the fate of the Shah Jahan?
No.
Learned counsel for on the other hand, learned additional public prosecutor has submitted that perusal of the case diary would be necessary. And hence call for the case diary. However, in the meanwhile, on the basis of materials available on record, as well as on the basis of the submissions made by learned counsel for the petitioner. The above named petitioners are hereby directed to appear before the investigating officer of Bilasipara PS case number 122/2024 within a period of 15 days from the date of this order and cooperate with the investigating officer. If they do so within the stipulated period of time, in the event of their arrest in connection with Bilasipara PS case number 122/24, they shall be allowed to go on interim bail of 30,000 each, of rupees 30,000 each, with one surety of like amount subject to the satisfaction of the arresting authorities with following conditions. Condition number 1 and 2. Let the case be listed again on 18/7 for case date.
Obliged. Hello.
Along with the AB case number 1560/2024.
1562.
1560.
May I please, Your Lordship? It is a 430 application. FIR is in page number 20, Lordship. Vernacular. And types copy of FIR is 13. May I read, Your Lordship?
What is the allegation?
The allegation is, the informant had a landed property but now she is residing at Dimapur. Landed property at Guwahati, but now she is residing at Dimapur. And on 9/6/24, when she came to her house at Guwahati, she found that some persons had illegally occupied her property and engaged private security guard. The security guard prevented them from entering their house and told them that property belongs to Harish Parekh, and he had engaged there. Then they informed the police at 2:30 PM. With the help of police, they entered their property and found that the accused persons had changed all the door locks of their house. They entered their house with the help of police by breaking the locks. Then they went to the second floor of their house, found Paresh De and his wife. The said Paresh De introduced himself as manager of the Harish Parekh and showed them false property documents. Taking advantage of busyness in checking the house, Paresh De and his wife escaped. The below named accused persons were prepared false sale agreement by forging her husband's signature. The accused person also changed the security camera system of their house and also found that all the belongings in their house, such as fridge, Godrej, AC, laptop, sofa, etc., are stolen. That the security guard who were engaged in their house, they stated before police that they were engaged by accused Harish Parekh, and the documents showing by security guard are totally false document, and they have suspect that they have made same false government document. There are four accused.
You are Harish Parekh.
No, Lordship, there are 4 accused in the FIR. I am for the Sankaracharya Vasumatari, the accused number 3, and the Judisthir Khaklari for accused number 4.
What is the allegation against them?
Their allegation, the documents, Lordship,
No, against Shankaracharya.
Against the accused number 3 and 4.
3 and 4.
Lordship, the security guard who showed the documents, the informant, in the documents, the name of accused number 3 and 4 are there as purchaser, Lordship. And my case is.
No, who purchased? Harish Parekh purchased or?
No,
You-
the property purchased by the accused number 3 and 4. And I am appearing for the accused number 3 and 4, the property purchaser. Lordship, the fact is, on 22/9/2023.
Property belongs to Veronica.
No, property belongs to the husband of the Veronica.
Who is the
Tonu De,
husband?
Tonu De, Mr. Tonu De. And the petitioners and the Tonu De entered into an agreement for sale
on 22/9/2023 for total consideration amount of rupees 52 lakhs.
But you were told that one Harish Parish,
Harish Parikh referred the security guard to the property, Lordship. Harish Parikh is one of the friend of accused number 3 and 4 who referred the security guard. It is admitted fact that the Harish Parikh referred the security guard to the accused number 3 and 4 as they are not the local resident of Guwahati. So they kept the security guard on there, Lordship.
but security guard told the petitioner, the informant that property belonged to Harish Parikh.
No, Lordship,
That is the-
they don't know, but
But-
as the Harish Parikh referred them,
Therefore, they informed
they,
that he
yes,
is the owner.
yes, Lordship.
But you are the owner actually.
Yes, Lordship, I am the owner. We are the owner, Lordship, the accused number 3 and 4
And you purchased the property from Veronica.
from Veronica's husband. Out of total agreed amount, 52 lakhs, we have paid 17 lakhs on till the 22/9/2023 in various installment. And thereafter, immediately after execution of the agreement for sale, which is annexed to the
No sale deed has yet been.
Lordship agreement for sale, sorry,
Okay.
Lordship. Annexure to page number 24, Lordship.
Now, what is your case?
And after husband of the informant handed over the property to us. And accordingly, he assured us that he will obtain the necessary sale permission within 2 or 3 months. But he delayed the process until the month of April 2024. Thereby, we contacted him, and on 1/5/2024, he finally denied and refused to obtain the sale permission and refused to execute the sale deed. Thereby, on 21 May 2024, we have filed a title suit being suit number 254/2024 along with a miscase for specific performance of contract and
254.
temporary injunction, Lordship.
250
Page number 29, Lordship.
254 of
254 of 2024, which is pending before the Honorable Civil Judge, Senior Division number 3, against the Tonu De, husband of the informant, Lordship. And after receipt of the notice from the court, the informant came on 9/6/2024 along with some police officials and took possession of the property
now the property is in possession of.
of the Veronica
Okay.
informant.
Let them appeal, Lordship.
Heard Miss, what is your name?
Adas, Lordship.
Heard Miss A. Das, learned counsel for the petitioner.
Lordship, in the meantime, interim may be provided. Yes.
Also heard Miss N. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, Common 1973, has been filed by the petitioners Shankaracharya Basumatari and Yudhishthir Khaklari, who are apprehending their arrest in connection with Patasi Lambari Police Station, case number 177/2024 under section 448/419/427/468/471/380/34 of the Indian Penal Code. The gist of accusation in this case is that on 11/6/2024, one Veronica Vijunamai had lodged an affair before the officer in charge of Ambari Police Station that she had a landed property at Hillview Road, Jyotikuchi, in the name of her husband. And they are presently residing at Demapur. Stop. It is also stated in the affair when on 9/6/2024, they came to the house when the informant came to her house, she found that the same was illegally occupied by the accused persons who are named in the FIR. And security guards are engaged in the said property. The security guards prevented the informant from entering into her property and told her that the property belongs to one Harish Parikh. Later on, with the help of police, the informant entered into the property and found that the door locks of the house were changed and some of the door locks were changed. In the second floor of the said house, the informant found one Paresh Dey and his wife, who introduced himself to be the manager of Harish Parikh and showed the informant certain property documents which were alleged to be forged, which the informant alleges that it contains forged signature of her husband. In the FIR, it is also alleged that some of the household articles like fridge, laptops, etc. were also stolen. So, on receipt of the said FIR, Patasi Lambari PS case number 177/24 has been registered. Learned counsel for the petitioners has submitted that the petitioners had entered into an agreement to sell in respect of the said property with the husband of the first informant, namely Tarun Dey, and in this regard, an agreement to sell, a written agreement to sell was also executed between the parties on 22nd of September 2023. It is also submitted by learned counsel for the petitioner that after executing the agreement to sell, the seller had handed over the possession of the said property with a promise to execute the sale deed after obtaining necessary sale permission for the sale. Stop. Learned counsel for the petitioner has also submitted that later on the seller denied to obtain the sale permission and execute the sale deed, and hence the petitioner had approached the civil court by filing a title suit number 254/2024, which is presently pending in the court of
Lordship,
which court it is pending?
Senior Division, Civil Judge Senior Division number 3, Kamrup
It's
Metro.
pending in the court of Learned Civil Judge Senior Division number 3, Kamrup Metro. Learned counsel for the petitioner has also submitted that presently the said property is in occupation of the informant and her husband after they entered into the said property with police help. Learned counsel for the petitioner has also submitted that the dispute between the parties are civil in nature and they are ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has submitted that the perusal of the case diary would be necessary. Hence, call for the case diary. Fixing 28 July for case diary. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed herein above, And considering the fact that the dispute between the parties predominantly appears to be civil in nature, both the above named petitioners are hereby directed to appear before the investigating officer of
Ambari Police Station.
Ambari Police Station. Investigating officer of Fatashil Ambari Police Station, case number 177/2024, within a period of 10 days from the date of this order, and cooperate in the investigation. If they do so, in the event of their arrest in connection with the Ambari PS case number 177/2024, the above named petitioners shall be allowed to go on interim bail of rupees 30,000 each, with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number 1 and number 2. Let the case be listed on 28 July. 28 July.
26 July. Service. Foxo Lordship.
POXO case.
Yes, my lord. Your lordship will find FIR at least 17, my lord.
The 438 application, there are only one petitioner. My lord, say, very peculiar type of case, my lord. The case of cryptocurrency and my lord, BitForex, my lord. That is
Cryptocurrency and
BitForex, my lord. I'll explain, my lord. Everything I have annexed, my lord.
okay.
And what happened? In fact, my lord, the complainant and my lord, and informant and my lord, myself with the same both brother, my lord. We are also investor, my lord. What happened in this? Your lordship, kindly see, page 13 is the FIR, my lord. Page 13, my lord.
Yes.
Complaint against serial number 1, 2, 3. One is before your lordship now. Last serial number 3, my lord, last line, your lordship kindly.
Oli Ahmed Bordbhuiya.
Oli Ahmed Bordbhuiya.
Oli Ahmed is a female or male?
Is a male, my lord.
Male.
I also, same question I put to my junior also, is a male. Sultana Ahmed Chaudhary, Mustafa Ahmed Loskar. Serial number 3, last line, your lordship. For fraudulent misappropriation of huge amount of money by deleting app of cryptocurrency. The main allegation is that app of cryptocurrency that is deleted from that app is deleted. So that is the allegation, my lord. Why it is deleted, my lord, I'll come to that, my lord. Now, my lord, your lordship, kindly respected sir, with due respect and humble submission, I am the inhabitant of above noted locality. Beg to draw your sincere kind and attention to make a high level inquiry and take into the high light the huge money scam done by the above noted miscreant. That sir, being an educated unemployed youth with a view to earning money, took membership of the cryptocurrency under the above noted miscreant and invested about 55 lakhs into the money exchange app BitForex. That sir, recently I have noted miscreant, above noted miscreant with a malified intent to delete this money exchange app BitForex. That sir, I physically meet with the miscreant and ask them to reason for deleting the money exchange app. Then they will file they fail to give any satisfactory reply to me. More even that they started hide and seek game with me with the above unreasonable argument. Hence, this petition with a pair will be asked to necessary step to recover the money from the above noted miscreant. Otherwise, I will face irreparable loss in injury. Accordingly, my lord, 120B 406 420 reduced 66 IT Act, my lord, has been registered. I will come to that later on, my lord. Now, my lord, your lordship kindly see what is, my lord, cryptocurrency and what is BitForex, my lord. BitForex, my lord, that is, my lord, that internationally it is 6 million users in 200 countries. It is government. It is, my lord, headquarters is in, my lord, Hong Kong.
Of what?
That BitForex, my lord.
What is BitForex?
BitForex is an app, my lord, just like a share market, my lord. That is, my lord, you have to invest money, and when share market rise, you will get you have to purchase the coins.
that cryptocurrency, my lord, that coin, my lord, you have to purchase, and then you will get that as and when it is rise, you will again it will be, everything has to be done in online. Now, my lord, your lordship kindly see annexure to page 15, my lord. Page 15, my lord. That government of India, my lord, banned it in India, my lord, because they have not paid any tax, my lord. Annexure to page 15, my lord. Page 15, my lord. India banned foreign cryptocurrency platform Spark Surge domestic exchange. India applied control over crypto tax excise, blocking foreign crypto information. Many investors had investment in them were left confused. So that was the news, my lord. That was the, my lord, in internet, my lord. Because they have not paid the tax, my lord, by the compare that BitForex, my lord, that is banned in India, my lord. So now your lordship kindly see, my lord, page 17, my lord. Then your lordship kindly see, my lord, page 16, then you'll go to lordship page 17, my lord.
Yes.
What is BitForex, my lord? Page 17, my lord. BitForex is a globally cryptocurrency exchange with low fees. So that is, my lord, globally, my lord, your last line, man, BitForex has a over 6 million user in over 200 countries and regions. So now, my lord, it is, what is BitForex, my lord? Is one of the leading cryptocurrency trading platform with a worldwide presence in over 200 countries. The company's headquarters is Hong Kong. Now, my lord, how to register? That is also there, my lord. Page 20.
No, how?
Page 25, your lordship kindly see, my lord, how it registered, my lord. Because he himself stated that I registered my name. How it has to register, my lord.
Page 25.
Page 25. How to register with BitForex. Easy and hassle-free registration is one of the best part of the platform, and does not require any personal information of the KYC verification. Users just need to register with their email, verification email, and etc. etc. So everything on online. So, my lord, I am also one of the investor, my lord. The other two, my lord, who are made an accused, they are also investor, my lord. Why they case file against me, my lord? Police should not have registered a case, my lord, because I also lodged a complaint against BitForex, and a complaint case has been registered because I also invest 13 lakhs, my lord. So, my lord, now, my lord, app is deleted because of the India government banned it, my lord. So for that, my lord, now
No, you cannot delete the app.
I cannot delete, my lord. That is
You
app,
can
my lord.
delete from your mobile phone only.
Yes, I can use only my mobile phone. I can done it from my part, but that app which was prevailing in the 200 countries, I cannot do it, my lord. Similarly, I also lose 13 lakhs, my lord. Initially, we get money, and my lord, I am not going to speak, my lord. Some of the advocates also of our court also, my lord, they are victim of this app, my lord. Now, my lord, because of the India government, my lord, banned it, my lord, because they have not paid tax, my lord.
So after banning, this app is not
App is
available.
no more, deleted by the company, my lord, in India, my lord. So that's why, my lord, your lordship kindly I made a statement. I also, my lord, my lord, where is the cause of action, my lord? Police should not have registered a case, my lord. Your lordship kindly see, I am a man from Hailakandi, and he is a man from Karimganj, my lord. In the app, my lord, on the online, my lord, investor names were found, my lord. That was earlier, my lord. Now it is, my lord, app is closed, my lord. He is not getting anything, my lord. When they are getting money, there is no complaint.
No, have you invested money through the
Yes,
have the informant invested money through the accused
no, my lord.
persons
Then he says that he has registered,
directly,
says
directly
registered.
to the company?
but otherwise, my lord, cannot, my lord. So your lordship kindly see, my lord, police, how this police actually, at least, my lord, it get me, they can complain they made to government of India, my lord. And that is, my lord, your lordship kindly see, government of India ban it, my lord. And also they also know, yes, some of the customers are, my lord, they are confused, my lord.
And from where it was deleted, it is not mentioned.
My lord,
That's it is alleged that the above miscreants with nullified intention deleted this app.
my lord, how can I delete app, my lord? That is a internationally applied app, my lord. And he registered to online, my lord. So may I pay that a CD may be called for, but ultimately, my lord, CD also get nothing, my lord. What they read, but my lord, even, my lord, otherwise, section 66 of the IT Act, that is, my lord, available. And 420, my lord, 406, my lord, 406, there is no entrustment, my lord. There is entrustment online to the, my lord, that foreign company,
Not to the petition.
not to the petitioner, my lord. So since there is no entrustment, my lord, 406 not will come, 66, my lord, I think it is available offense, my lord. So
And
may I pay that, my lord, your lordship kindly call for the case there, and in the meantime, I will be
Mr.
protected.
T.J. Mohanta, learned senior counsel, assisted by Mr. F.A. Loskor, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 438 of Code of Criminal Procedure, 1973, has been filed by the petitioner Oli Ahmed Bordhuya, alias Oli Ahmed Bordhuya, who is apprehending his arrest in connection with Ratabari PS case number 126/2024 under section 120B/406/420 of the Indian Penal Code, read with section 66 of the Information Technology Act, corresponding to GR case number 1168/2020. The gist of accusation in this case is that on 6/6/2024, one Jahan Uddin had lodged an FIR before the officer in charge of Ratabari police station, naming 3 accused persons therein, including the present petitioner, inter alia alleging that the informant, along with the present petitioner, along with the accused persons named in the FIR, invested about near about 55 lakh rupees in exchange app, 55 lakhs after taking membership of cryptocurrency in money exchange app BitForex. It is also alleged in the affair that recently the above named miscreants, recently the accused persons named in the FIR with a malified intention deleted this money exchange app BitForex, for which the informants suffered monetary loss. On receipt of the said FIR, the Ratabari PS case number 126/2024 was registered. Learned senior counsel for the petitioner has submitted that BitForex is a leading cryptocurrency trading platform with a worldwide presence in about 200 in about over 200 countries. However, recently the government of India has imposed ban on said cryptocurrency platforms. And therefore the BitForex cryptocurrency app is no longer operative. Learned counsel for the petitioner has submitted that the petitioner himself had invested money in
13 lakhs of rupees.
13 lakhs of rupees in the said money exchanger app. However, after the said app is no longer operative, they are unable to invest any money. It is submitted by the petitioner that it is submitted by learned counsel for the petitioner that the petitioner cannot delete or the said app, as the said app is operated by an international company and which is not under the international company having its headquarters in Hong Kong, which is not under the control of the petitioner in any manner. Neither any allegation to that effect is there in the FIR. On the other hand, an additional public prosecutor has submitted that perusal of the case diary would be necessary, hence call for the case diary. However, as it appears from the documents annexed along with the bail application, that the said app is operated by an international company. The question of, moreover, it is not clear from the FIR as to from where the said app has been deleted, where the informant is alleging as to what the informant means when he is mentioning in the FIR that the said app has been deleted. That is, whether it has been deleted from his mobile or whether the said app has become inoperative. In both the cases, the petitioner may not have any role in the same. Hence, the above named petitioner is directed to appear before the investigating officer of Rathabari PS case number 126/20
Within 10 days, my lord.
within 10 days of date of
That is
this order and cooperate in the investigation. If he does so within this said period, within the stipulated time, in the event of his arrest in connection with aforesaid case, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, 1 and 2. Let this case be listed again on 25th of July
Deeply opposed. Deeply opposed.
for case diary.
This is that letter where we are challenging the proceedings under 138. Lordship, hopefully I can satisfy. Lordship, for appreciation of the submissions for that, may I take your lordship to the complaint first? As I had submitted on the other day, at the first instance, cognizance was not taken. Page 19 is the complaint petition. I'll just take your lordship to the relevant paragraphs, which lays out the
What was
facts.
the allegation? Will you
No.
refresh my memory?
Yes.
it is a complaint under, pointing to an offense under section 138 of the NI Act. The facts are that the present petitioner, who is a drawer of the check, had issued a check for pre-close towards some liability towards the complainant. And that she had, and he had deposited the check, and the check was dishonored with the indication account blocked under 2125.
Yes.
That was the what
Account
was
blocked.
written under 2125. That is what is written. If your lordship peruses page 21, paragraph 5 of the complaint petition.
Account blocked.
Yes, account block situation covered in 2125.
Page,
Now,
page.
page 21 of the complaint petition, paragraph 5. Complainant begs to state that he presented the said check at his banker at Federal Bank Fancy Bazaar branch on 9/5/2018, and to his utter surprise, his bank has dishonored the aforesaid check due to the reason account block situation covered in 2125. That is what was in. After that, taking into after examining the complaint petition and the complainant also, what the order at page 30, if your lordship peruses the order at page 31. Magistrate does not take cognizance. Page 31. Order dated 21/6/2019.
Yes, further inquiries.
Yes, 21/6/2019. I'll just read out a few lines.
Okay.
Complainant is
So
present.
first he took a view that complainant is not responsible for blocking.
Yes, he has, what the learned court below observes is that the reason, upon due consideration, prima facie, it is found that the check in question alleged to be issued by the accused was not dishonored because of the amount of money standing to the credit of account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from that account. What is there in section 138? The reason of dishonor as shown in banker's slip is only account block situation covered in 2125. As such, without knowing the actual reason of dishonor of check, it cannot be found prima facie that the accused is responsible for the dishonor of the check. That is what the observation of the court is, that prima facie, it has not made out a complaint under section 135. That is what is indicated, what is reflected from the said order. And thereafter, that is why the bank manager was, then thereafter the complainant files a petition. If your lordship,
On the
it was
same
page
day?
32.
On the
Page
same day?
32. Yes, same date, later on. Page 32. If your lordship peruses the entire order sheets, the complainant was absent on most of the days. And all these petitions were filed later on. After the, later on, seen petition number 7360 filed by the complainant, praying for issuing summons to the branch manager of the banker of the accused to give evidence to clarify the reasons of the dishonor of the check. Third, the branch manager or authorized representative of Vijay Bank Khanapara branch has been cited as a PW by the complainant in his complaint. Evidence of said witness is felt necessary for the purpose of inquiry in this case. Learned advocate has submitted that being an official witness, the branch manager or authorized representative will not appear if summons is not issued. Considering all prayer of the complainant is hereby allowed, the branch manager may authorize some other competent officer to represent the bank. Why I'm reading out this? Because the branch manager himself did not come, an authorized representative was sent. Now, after this, if your lordship peruses the statement of the authorized representative of the bank at page 34. 34 is the original and certified copy, and 33 is the typed copy. If I may read out from the typed copy at page 33. I am the authorized representative of the Bank of Baroda. The erstwhile Vijay Bank is amalgamated to Bank of Baroda. I am here to depose regarding dishonor of check which is enclosed as Exhibit 2, that is the return memo. Account of the accused was blocked as the KYC was not submitted by the accused for what it could not be updated. The block account is one of the reasons for dishonor of the check as per my understanding. So the complainant himself says block account as well as the branch manager says blocked account. Now, your lordship may kindly peruse the order by which the complaint was taken cognizance at page 39. 39, order dated 7/4/2021. May I read the order, lordship?
Relevant portion you,
Relevant portion, paragraph.
or you
4.
may read the order.
Yes. Matter is lying at a stage of taking cognizance of the offense under section 138 of NI Act. Peruse the case record. It reveals that by order dated 21/6/2019, the learned predecessor court made an observation that the check in question alleged to be issued by the accused was not dishonored because of the amount of money standing to the credit of the amount is insufficient to honor the check, or that it exceeds the amount arranged to be paid from the account. The reason of dishonor as shown in the banker's slip is only account block situated covered in 215. As such, without knowing the actual reason of the dishonor of check, it cannot be found prima facie that the accused is responsible for dishonor of the check. In the backdrop of the above facts, as the further inquiry was felt necessary, the branch manager of the concerned bank was examined as CW1 and discharged. On consideration of the complaint petition, the evidence in affidavit and examination of the witness, it is found that the account block is one of the reasons for dishonor of the check. Although it is not specifically found whether account block is also responsible for bouncing the check, but account frozen is one of the reasons for dishonor of the check, and account frozen is similar to account block. Now, wherefrom he got account frozen? The branch, neither the complaint petition states that the account is frozen, neither the branchman, the authorized representative of the bank in his statement has deposed that the account was frozen. Above all, it is the accused who is primarily responsible for blocking of the account and subsequent dishonor of the check. Hence, upon due consideration, it is found that prima facie there are sufficient grounds for proceeding. Accordingly, cognizance of an offense under section 138 of Negotiable Instrument Act has been taken against the accused. Now, lordship has to apply his mind at this stage. Honorable Apex Court has made it very clear in various pronouncements that at the time of taking cognizance and issuance of process, especially against an accused who resides beyond the jurisdiction of that trial court, then
Where do you stay? Where do you
presently
reside?
I stay in the state of Haryana at Gurgaon.
No, at the time
At
of
that
the,
time, they were residing at Dubai. The petitioner, she was working there as she was a doctor for around 40 years. She was there, and after that, after her retirement, she has shifted now to India, and presently she is at Gurugram. And lordship, at this stage, at the time of issuance of process and at the time of taking cognizance, the magistrate is required to apply his mind. That is what the Honorable Apex, not a detailed order, not a speaking order, but at least the application of the mind and his satisfaction has to be recorded. Now, where is the application of mind and where is the satisfaction of mind from this satisfaction of his from this paragraph? Where is the
magistrate says that you are primarily responsible for blocking of the account.
prior to that, the reason at the order which was passed after the complaint was filed in the year 2019.
Yes.
What
Yes,
it
Jahan,
says,
you were representing.
it's a
Yes.
complaint.
I was there, but complainant, I think notices have gone to the complainant, they're yet to come.
We have not yet issued it.
Oh, acha, acha.
The question is whether to stay.
Because otherwise what
The-
yes.
The point to be considered is whether the petitioner was at fault for dishonor of check. Her contention is that while arriving at the decision that the petitioner was fault, the court did wrong reasoning. It mentioned that the account was frozen. However, in the check rejection slip, the reason was not frozen, is not mentioned anywhere.
No,
It is mentioned that account was blocked for some this
for
case.
reasons stated under 215, that is what is stated.
Otherwise blocked or frozen. I think both comes under 138. Block
No,
na hai.
It is not yet decided, no.
Not there.
I
But
can-
then
I
few
can
high court
place-
decisions
no.
are there.
No, there are no high court decision frozen on frozen at
Okay,
this
let
point of
us
time.
decide.
And lordship, I can place
Let us issue notice. Till
Lordship,
returnable date, we are
Lordship, prima facie, it shows there is no complete, there is no application of mine which is required to be done. I can, may I please Supreme Court decisions on that point, or will be required or not?
Stay
Probably,
You have ready
yes, yes.
once
Yes.
on the application of mine.
Yes. Lordship, this is a decision, judgment written by our present CJI. So,
Relevant para.
paragraph 32 onwards.
Heard Miss D. Borgohain. No, otherwise it is accepted that while arriving at a decision, it has to be a reasoned decision.
No,
Yes,
has to be a
yes.
reasoned
Reasoned
decision.
decision.
And especially at the time of issuance of someone's process against accused who resides beyond the jurisdiction. That was laid down in Pepsi Foods way back in the year 1998 itself. Paragraph 32 of that decision, may I just read out, Your Lordship?
It's a long paragraph.
It's a long decision, but only the relevant paragraphs 32, 33, 34.
No, okay, no need. We are issuing notice.
And not sure, of course, because we have made out a case for stay.
Depot too.
Prima
Okay,
facie.
I'm giving.
Yes, Lord.
Last time also Lordship indicated his data.
Heard Miss D. Borgohain, learned counsel for the petitioner. Also heard Mrs. Jahan, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Dr. Sumati Chand Kakoti, who is aged about 91 years, for quashing of proceeding in NI case number 4639 / which year the case was filed?
2018.
4639 / 2018. Learned counsel for the petitioner has submitted that the respondent number 2 had filed a complaint under section 138/142 of the Negotiable Instrument Act 1881 before the Chief Judicial Magistrate complaint. Chief Judicial Magistrate Kamrup Metro, inter alia, alleging that the check issued by the present petitioner in the name of, for whom it was issued, the
complainant Komota letter.
the complainant was dishonored by the bank, that is Federal Bank Fancy Bazaar, when it was presented for encashment on 9/5/2018, and the reason for dishonoring the check was mentioned as, within inverted comma, account blocked, situation covered in 2125. Learned counsel for the petitioner has submitted that though the complaint was filed on 27/7/2018, however, the learned Judicial Magistrate First Class did not issue the notice immediately and felt necessity of conducting an inquiry. And accordingly, the complainant's witness number 1, that is an employee of who is an employee of the Vijay Bank, was examined as CW1. and thereafter by order dated 7/4/2021, that is 3 years, almost more than 3 years after the filing of the complaint, the learned judicial magistrate first class took cognizance of the offense under section 138 of the Negotiable Instrument Act against the present petitioner and issued processes to her. It is submitted by learned counsel for the petitioner that at the time of filing of the aforesaid complaint, the petitioner was residing at Dubai, that is outside the jurisdiction of the court where the complaint was filed. And therefore, it was incumbent on the learned judicial magistrate first class to arrive at a to reason what this decision says.
Pepsi food.
No,
nahi?
Pepsi food is with regard to issuance of
Application of
summons,
mine.
application of,
To
yes.
to have applied its mind before issuance of process to the present petitioner. However, it is submitted that bare perusal of the order taking cognizance shows that no such application was there, as in the order itself, learned magistrate has presumed that the reason blocking of account is equivalent to freezing of account without any basis for the said conclusion there on record. And hence, she has submitted that there was no proper inquiry before issuance of processes against the present petitioner. Issue notice to the respondent number 2. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. However, as regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable on 28th of July 2024. In the meanwhile, considering the fact that the reason for dishonor shown in the banker slip is account is apparently not the within inverted comma account frozen, but blocking of the account inverted comma close. Hence, it appears that the contention made by learned counsel for the petitioner has some force in it, and therefore, till the next returnable date, the further proceeding of CR case number 4639C/2018 shall be kept in abeyance. Please record.
Lordship. We'll have to examine that issue, whether it at all lies, it will come under 138. Because I found some decisions favoring this side, some that side, so.
Okay, we'll examine.
Yes, there requires examination,
Let you take back this.
because there are no Supreme Court decisions on that point. frozen and
Let the,
Blocked.
let the respondent number two appear,
Yes,
we'll
yes,
examine.
Lordship. Yes, Lordship.
Hmm?
Ob-
Date is 28,
28
28
July.
July,
28 July, Lordship.
or 27 July. 28 is Sunday.
Lordship, can it be on the, in the first week of August, if it's convenient?
Okay, let it be in the first week of August. 5th of
I think the
August.
courts have gone into voluntariness of the act. If somebody does it voluntarily,
That
then
is the reason.
that
It's-
is the,
Yes, if it's for reasons other than what is prescribed there in
It is
138.
beyond his control.
beyond
Yes,
his
yes.
control.
Then,
Yes.
Perhaps 138 will not come.
but he has not provided the KYC detail.
Acha.
No, even the RBI guidelines mandate that for non-updation of KYC, the bank cannot block
the
the account, or that the RBI guidelines clearly says.
So it needs to be examined.
Lordship. Obliged.
24.
24. 24. Oh, no, fine, আমি নহয়.
May it please your lordship.
24 is Abhiya.
Yes.
May it please your lordship, my lord. This is a 439 application, my lord. Here the petitioners were arrested, my lord. On, my lord, 22/11/22, my lord. 22/11/22, my lord.
How much time?
My lord, here, my lord, charge sheet has been laid, my lord.
What is the time?
My lord, now, my lord, from the date of detention till date, my lord, 1 year, 7 months, my lord.
When the charge sheet was laid?
My lord, I'm coming, my lord. Charge sheet was charge sheet was laid on, my lord, 18/05/23. Citing 10 numbers of witnesses. And on 04/08/23, my lord.
Who is
charge-
there? Who is the other side?
My lord, DRI, my lord, Mr. Kayal, my lord. And
They have to be.
it's a regular practice, my
Teacher.
lord. Last 2-3 times, my lord, they're doing.
Has come. Yes.
Now, my lord, 18/5/23, my lord, final report, my lord, 10 witnesses, my lord. And my lord, 04/08/23, my lord, charges were framed. Under section 21C, 23C/29, my lord. But till date, my lord, none of the witnesses have been examined, my lord.
What was the
My lord, it's my lord,
contraband?
792 grams of heroin, my lord.
Yes.
And my lord, they have filed an objection, my lord. In the objection, my lord, I have gone through it, my lord. My lord, they have, my lord, blamed the court, in fact, my lord. Yesterday, the case was fixed for, my lord, evidence, but my lord, the PW didn't turn up, my lord.
Yesterday, what was the date?
Yesterday was the date, my lord, fixed for, my lord, witnesses, a production of witness, my lord. They did not turn up, my lord.
Okay, then? Yes, and continue your submission.
My lord,
What is your ground?
My lord, that lordship, my lord, that judgment, my lord, Chitta Biswas, my lord, alias Subba versus State of West Bengal, my lord. My lord, that case, my lord, the apex court granted bail to the petitioner who was facing a trial, my lord, for possessing a commercial quantity of contraband on the ground of, my lord, prolonged incarceration, my lord, that is of 1 year, 6 months, my lord.
Anything else?
My lord, that your lordship judgment, my lord, your lordship has discussed all those judgment, my lord.
Okay.
That
Yes, Mr.
paragraph 7 onwards.
Lordship, in this case, record is still 28/11/2023, Lordship. So Lordship, up to date case record may be called for Lordship.
No, but
And Lordship, charges frame on 4/8/2023, 31.
have any, they are submitting that yesterday it was fixed. And
Yes. That
Lordship,
is submitting on bar, my lord. I'm submitting on bar, my.
They are
Yesterday-
submitting yesterday it was fixed and no witness has been examined.
Lordship, I will have to obtain information from the department, Lordship. And up to date case record is not received, Lordship.
You seek
I have
instruction
gone through the record, Lordship. So,
or you submit some document to show that.
Yes, my lord. My lordship, today is Tuesday, my lord. Day after tomorrow, my lord, I will submit the copy, my lord.
Okay, let them also inquire.
Yes, my lord. My lord, in fact, they have filed this objection, my lord, last week, Friday, my lord. They have not stated anything, my lord. Then what is the use of filing this objection, my lord? Now she is raising the point, my lord, record will be required, my lord. On what basis?
No,
they-
record, we are not calling for.
Yes, my lord. On what basis they have filed this, my lord, objection, my lord?
We are not calling for fresh record. No, let her inquire.
My
You
lord.
Okay, Lord.
inquire. Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Ms. M. Deka, learned counsel for NCB. Learned counsel for the petitioner has submitted that till date no witness has been examined in this case. In the case pending before the trial court. However, Ms. Deka, learned counsel for the NCB has submitted that the record, the scan copy of the case record which is available is updated only up to May, only up to
28/11/23.
only up to the month of November 2023. And she need some time to inquire about the status from the department. On the other hand, learned counsel for the petitioner has submitted that the case before the trial court was fixed on yesterday. That is on 24/6/2024, and no witness appeared, and till now not even a single witness has been examined by the prosecution side. He also seeks some time to produce the proceeding of the court, the order sheet.
Right.
In this respect, and prays for listing this case before on day after tomorrow, to which the
27.
counsel for NCB also agreed. Hence, the prayer is allowed. Let this matter be listed again on 27 July.
Lordship,
I'm
there-
obliged.
This is, there is correction, Lordship, DRI meter.
Oh, instead of NCB, counsel for DRI. Okay, day after tomorrow.
I'm obliged, my lord.
Highly obliged.
26, this is a POXO matter, the notices have gone. It was received by the inspector of the concerned police station, OC of the concerned.
May I please your lordship? My lord, this is 439, my lord. The petitioner was arrested on 17/10/2023, my lord.
17, 10, 20.
23.
23 or 22?
My lord, 23. 3.
Then what is the period for which you are behind the bars?
My lord, almost 8 months, my lord. I am in
Last
custody.
occasion, he was supposed to show some judgment where your lordship has made
What
some
was-
query to show that 8 months is a prolonged incarceration.
Oh, yes. You are ready with those judgments?
My lord, I am ready, my lord.
Yes.
First of all, my lord, before I,
No, you
Yes,
have
of
to be very specific.
true, my lord.
My query was, though prolonged incarceration may be a ground for getting bail, even in a case involving commercial quantity of contraband. My query was whether 8 months is long enough. Do you have any authority to support?
My lord, to that respect, my lord.
Only to
My
that
lord,
extent.
Yes, to satisfy this question, my lord, I'll have to, my lord, show, my lord, the ingredients, my lord, under which, my lord, the case. In the case. My lord, in fact, my lord, if your lordship, my lord, pleases to see the FIR, my lord, page 14.
No, we have already heard on in that regard.
No, my lord, I am coming to that, my lord. But prior to that, my lord, what I am trying to submit, my lord, is that, my lord, 222C and 29 has been slapped, my lord, against me. My lord, which with all respect, my lord, I would like to submit that 22 does not, my lord, is not applicable at all in this case. Only 29 may attract, my lord, with all respect. Because, my lord, there is no direct evidence which led to, my lord, that, my lord, the contrabands, my lord, that has been recovered from the possession of Idris Ali. My lord, I am appearing for Idris Ali. There are altogether three accused persons. My lord, accused number 1, Habibur Rahman. He has come from, my lord, Manipur with a bag, my lord, which containing, my lord, this contrabands, my lord, Yava tablet, which has been, my lord, tested as, my lord, methamphetamine, my lord. Now that is almost 5 kg something. That, my lord, there is nothing in the FIR, nowhere in the charge sheet, my lord. That, my lord, it has been recovered from the possession of the Idris Ali.
No.
Because admittedly, my lord, bag belongs to, my lord, Habibur Rahman, who brought it from Manipur. That is what the case of the prosecution, my lord, if I am not wrong.
No, but there are materials against you under 29.
My lord, that is there, my lord.
Assuming that, okay, we are going for lunch with a question. We will continue to assuming that there is no material under 22C against you.
My lord,
There is only material against 29.
29, then, my lord,
29, but involving commercial quantity.
my lord,
Then
if there is 29, my lord, 29 says, my lord, complicit, conspirator,
yes.
abettor, my lord.
No, have you understood my question?
My lord.
Assuming that there is no material under 22C, materials are against you under 29 only. Let us assume.
Yes.
Then whether case is in your favor, whether section 37 would not be applicable in this case. Still it will be applicable because the quantity of contraband seized in this case is commercial quantity. You will get benefit only if you are able to satisfy that 8 months are prolonged enough.
Incarceration
So
of 8 months.
for that, we'll continue
After break.
after break. You will get only 5 minutes time.
My lord. My lord, before that, my lord, I would like to point out that, my lord, section 29, my lord, punishment, my lord, of criminal conspiracy. Now, my lord, criminal conspiracy.
How much,
My lord,
how much incarceration in this case,
my lord, it
the
is, my lord,
judgment which you have cited, K. A. Nazib,
my lord,
1 year, 6 months,
1 year,
Nazib.
6 months, yeah.
But you have completed only 8 months. It
true,
is,
my lord,
it,
but considering the punishment, my lord, your lordship kindly
Punish-
consider section 29.
what is the punishment?
Yes, my lord, 116, my lord, kindly see. 29 says, my lord, 116 of IPC. My lord, abates, conspiracy.
No, what is the punishment for 29?
Punishment, my lord, it says 1/4 of the punishment, my lord. Wait a minute. 116, my lord, like lordship kindly see, my lord, 116 of-
IPC, punishment is prescribed in the NDPS Act itself.
Yes. My lord, section 29, it says, my lord, that, may I read, my lord, section 29. An item. Whoever abates, has your lordship got it, my lord? Section 29 of NDPS.
Yes.
Whoever abates or is a party to a criminal conspiracy to commit or an offense punishable under this chapter shall, whether such offense to be or be not committed in consequences of such abatement or in pursuance to such criminal conspiracy, and notwithstanding anything contained in section 116 of the Indian Penal Code, be punishable with imprisonment provided for the offense. Now, my lord, your lordship kindly see, my lord, section 117 of 116 of IPC.
Well, here it is notwithstanding anything contained in 116.
The punishment is the
Commercial
punishment provided for the offense.
Offense itself, my lord.
What do you want to say?
Paragraph 19 of the judgment that I have said it. Paragraph 19.
That judgment does not help you.
My lord,
Oh,
there also.
Okay, heard.
My lord, your lordship kindly, may I read the judgment?
No,
Only
only
2 lines, my lord.
no, because you are wasting time. You are
Wasting
not
time. This is the third day,
you are not to the point. I have raised a specific query to you
My lord,
because I have understood your submission. Your
Hello.
main submission is that on the ground of prolonged incarceration, you should be granted bail.
my lord.
You are behind the bar since last 8 months. My only query is whether in NDPS case, do you have any authority where for undergoing 8 months,
Incarceration, my lord, incarceration, my lord.
8 months is also long enough for, is that your submission?
My lord, yes, my lord.
Okay,
And my
okay.
lord, if, my lord, at the same time, your lordship will have to see, my lord, whether there is a possibility of, my lord, end of trial within shortest possible time, my lord. In my respectful submission, my lord, your lordship kindly see, my lord, this is the order passed by the learned trial court, my lord, on 6th of June 2024.
Okay,
My lord,
so
your lordship kindly see, kindly peruse the order, my lord, I have given it, my lord. Lord, it says, my lord, accused Habibur Rahman and Muhammad Idris Ali are produced from Central Jail, Guwahati, and are remanded back till next date. Number 2, learned counsel for the accused Muhammad Habibur Rahman is present and has submitted that accused Mohammad Alimuddin is in Dhubri jail. Accused Habibur Rahman and Mohammad Idris Ali have also said that co-accused Mohammad Alimuddin was
Okay,
taken
now
away.
what is your submission?
My lord, now, my lord, it is fixed for your lordship will see
Copy.
4/7/2024 for production and copy. My lord, your lordship, kindly see, my lord, there is no possibility, my lord, for early trial or early end of trial, my lord.
Okay, I'll consider,
my
I'll
lord,
consider your submission.
Yes. So in
You-
that view of the matter, my lord, the accused persons, my lord, accuse a right, my lord, under Article 21 of the Constitution of India, personal liberty, my lord. Your lordship knows, my lord, nobody shall be deprived from.
Okay, no, that I have understood. You need not to again
My
make submission.
Now, 8 month incarceration, my lord, in my respectful submission.
Is long enough.
Long enough.
Yes, that
That is
I
my
want.
respectful. Considering,
Anything,
considering his involvement, my lord, assuming under section 29 of the NDPS Act.
considering the fact that he is not directly involved in the.
He is
offense.
not involved, my lord, with all respect, my lord. And this is, my lord, and my lord, he will not be guilty of the
Mr.
offense.
B.K. Sen, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor. Let this case be listed for delivery of orders on 27/6. On 27, I will. Okay.
I am obliged, my lord.
Yes, next one.
Item 28. May please, your lordship. This is also case also, my lord, under also, my lord. But I mean, discuss actually in the.
My case is something else, my lord. He is not named in the FIR. Main
You are
person,
not named,
no,
but
not
charge sheet, you are charge sheeted.
charge sheeted. Charge sheeted now. Charge not yet framed.
Charge not yet framed,
Yes.
MBW the issue.
I only take my lord, your lordship, kindly see. That is page 40, my lord, 44 is your Caesar list, just one. Page 4 is yours.
No, what is the case?
Case is matter from the auto, one Ruel Ahmad from auto, he was coming. And ultimately 191 kg of ganja was found inside the vehicle.
191 kg.
One kg found in the vehicle. He was arrested, another person was there, my lord, he fled away. So far, I am concerned, my lord, according to this, my lord, as per their statement, they have gone to my house and they have recovered 12 kg, 12 something plus kg from my fishery. This is
12
the
what?
12 kg ganja, my lord.
12 kg ganja.
Yes, 12 plus something.
Separate recovery.
Separate recovery. That is what page 40, my lord, I'm just saying.
Page
Page 40.
40. Yes.
Yeah. 40, my lord. Your lordship will find description is the date is also my 13/4/23. Here date of occurrence is my 12/4/23. At 3 p.m., one packet containing ganja marks so and so. Then circumstantial seizure. The seized one packet of ganja recovered at the bank of a fishery under the premises of Ahmad Ali, the present petitioner. The fishery is situated in front of the house of Ahmad Ali, and the narcotic germs were concealed at the bank of the fishery.
Okay.
Now you will kindly find next other seizure list is page 34. Page 34. That is on 12/4/23.
How both the seizures are linked?
They say, my lord, because on the basis of the statement of the
other accused matter, they have gone to my house. So they said matter 29, section 29 is. This is how they have done. But I am nowhere connected with next day, neither FIR, no whisper against me in the FIR also. And just your lordship kindly have a look to pay. That is page 42, my page 40.
Yes.
Page 42.
Yes.
During interrogation, the accused person stated, accused means by the main person, that on 12/4/23, at around 6 p.m., one person, namely Ali Amjad.
What is your name?
No, I am not. My name is not
Ahmed
there.
Ali.
I am Ahmad Ali. The Ali Amjad, he fled away. Subsequently, he was also arrested. Huh?
No,
Declared
declared
absconder.
as absconder. NBWs are issued.
Yes. Yes, thank you. So, one person, namely Ali Ajmal, so and so hired him along with his auto rickshaw to transport narcotic drugs from so and so. Accordingly, the accused person went to Kunti and via coming to Chankia after loading ganja packet. On the way, police caught him, but Ali Ajmal fled away, who was escorting with the way. I am no connected there, madam. So this is my case. And I follow English for last more than 1 year, madam. 1 year, 2 months.
Charge sheet has been laid under section
42.
42 I don't have.
Page 42, right?
No.
Charge sheet has been laid under section
22 B to C,
22 B2C/29.
29 of the NDPS Act.
What is the material under 29? You have to check.
Mm.
If there is, how both the seizures are linked, connected.
Yes, how that I have seen that what I see is that
Take the
the
record
person,
also.
the person who is arrested in the beginning from that auto rickshaw, he said that he and one another person bought the articles from Ahmed Ali.
Ruel Ahmed.
Ruel Ahmed,
Rueluddin.
along with one another, brought those seized articles from the petitioner.
But page 42 is
They went to the petitioner's house and seized those 41 kgs, those
12 kgs.
12 kgs, no 41, 12 kgs.
Like, yeah, 12 kg from
Ahmed Ali's atta.
But
Ahmed
that is a
Ali.
separate seizure.
That is a separate seizure from his home on the basis of the statement of the co-accused. Ah.
This page you read, nothing against page 42.
And as far as the case is concerned, NBWs are issued against the absconded accused. Now it is at the production stage. Altogether, the ganja comes to 191 kg.
That is another aspect, but
That
two
is-
seizure list.
Two seizure lists.
191 including this 12 kg.
No, excluding, no,
That is
excluding.
page 34, madam.
34.
No, my query is, as regards 191 kgs of ganja, which was seized on the first day, that is
The
on
12
Yes.
from the vehicle.
12.
Mm. This is
How
different.
the petitioner is linked, apart from the statement of the
Ever.
co-accused.
What I can see is only the statement of the
Only
co-accused.
statement of co-accused under section 6. Is there any other material? If there is any other material, then
In order to link, there is only one material. Other witnesses have stated that we were there and the articles were seized.
regarding first seizure.
Regarding second seizure also.
Second seizure is of not of commercial quantity.
12 kgs.
And 1
But
year,
then
1
state-
year, 2 months.
This is at a very nascent stage. I mean, the trial is yet to start, charge is yet to frame.
No, as regards bail, we are concerned.
She has no case, madam.
No, but facts,
Kuntu dekhala apni last of
Last
to?
page to last page. What to finish on?
No, eta.
No last page.
No, 42 night.
42 page. Or 80. Okay, let me see. Clear cut because say that Adnan absconded, he hired them.
This person here is
Roeluddin.
Roeluddin.
Yes. So same thing 43 page. Matter it will be an type of type.
But,
What is your name?
Ahmad Ali.
but Lordship
But
is,
in your forwarding, it is mentioned that 41 packets of ganja was seized from your possession.
No, how it can happen? They are writing will not do well.
no, 1 to 41 is from Royaluddin,
Yes.
from the auto rickshaw. That comes to 191 kg.
Separate in presence of witness which found. Why did I am having the my lord forwarding report? From the spot he was arrested now.
Page number 20, Lordship will see this. Page number 20, the first few lines. During interrogation, accused person Royaluddin, it is learned that he, along with a absconding accused Ali Ajmal, who is still absconding, bought the seized 41 packets of suspected ganja from below named accused person, that is Ahmed Ali.
Yes, apart from this statement, what is there?
I don't find any other materials. Lordship can give me that once. I've seen if I remember something. আৰু তাৰপিছত কিমান পালে?
Then they will get benefit of.
Also the forwarding report of Royal.
He is the main supplier, he said, of 41 packets. There's other materials.
What other evidence is there?
Hmm. And during the search, 1 packet of ganja packed by plastic packet is found in the bank of a fishery of Ahmed Ali, which is concealed at the bank of the fishery.
How much?
1 packet. So
12 plus anything. 12.
Where are you reading?
no, from the case diary.
Okay. Now, Mr. H.R.A. Chaudhary, London, Senior Counsel assisted by Mr.
R.A. Mazumdar.
R.A.
Mazumdar.
Majumdar, Learned Counsel for the petitioner. You go through, Ms.
Lordship.
Jahan, if
Lordship,
you can
yes.
find out. This application under section, also Ms. H. Jahan, Learned, Additional Public Prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Ahmed Ali, who has been detained behind the bars
Since 14/4/23.
since 14/4/2023.
1 year, 2 months, 11 days.
14/4/2023, within bracket, for last more than 1 year, 2 months, in connection with special NDPS case number 35/2023, corresponding to Bajari Chera PS case number 86/2023, pending before the Court of Learned Special Judge Karim Ganj. The gist of accusation in this case is that on 12/4/2023, one A. Mohanto, in charge of Pathaltoli watch post, lodged an FIR before the officer in charge of Bajari Chera police station, inter alia, alleging that on receipt of specific information through reliable sources regarding concealment of huge quantity of ganja, regarding transportation of huge quantity of ganja from Kurti village towards Sondrokhira in a Bajaj auto rickshaw bearing registration number AS 10 AC 8213, a Naka checking was conducted. Naka checking was organized near Kurti Bridge. During the Naka checking operation, the police party intercepted one auto rickshaw coming from Kurti village and
নাজানো দেই, দেখাতো নাই।
the
audition থাকিব পাৰে।
the said auto rickshaw was driven by one Ruel Uddin alias Jahir Uddin. And on search of the said auto rickshaw, 41 numbers of packets of ganja wrapped in plastic tapes were recovered therefrom. On weighing the said recovered ganja, the weight of same was found to be 191.005 kgs. During interrogation, on the basis of the said FIR, on receipt of the said FIR, Bajari Chera PS case number 86/23 was registered. During investigation, while the arrested accused, namely Ruiluddin, was interrogated, he disclosed that the recovered ganja was purchased, was brought by him from the present petitioner, and accordingly, police arrested the present petitioner. It is also pertinent to mention herein that on the next day, that is on 13/4/2023, at about 3 p.m., a search was conducted by this officer who seized the ganja on the previous day, that is Shri A. Mahanta, SI of police. No, क्या लिखा? Then last line too. In the premises of present petitioner Ahmed Ali, and one packet of ganja, one packet containing ganja weighing about 12.310 kg was recovered therefrom. After completion of the investigation, charge sheet was laid. When the charge sheet was laid?
Charge sheet was made by not
31/7/20.
31/7/23.
Charge sheet was
July 23.
laid against the present petitioner and two more accused.
One
Yes.
accused already arrested earlier, other was absconder. We came to know he has been arrested 2-3 days back.
And two more accused persons. Learned counsel for the petitioner has submitted that the quantity of ganja seized from the premises from the bank of the pond fishery belonging to the present petitioner is only 12.310 kg, which is less than commercial quantity. Learned counsel for the petition, learned senior counsel for the petitioner has also submitted that the recovery of commercial quantity of ganja, that is 191.005 kg, was made from the possession of the co-accused Royal Uddin. And with the said recovery, the present petitioner is no way connected. It is also submitted by learned counsel for the petitioner that the only incriminating material connecting him to the first seizure is the statement of co-accused Royal Ahmed,
That's
which,
the only one.
according to learned senior counsel, is inadmissible in evidence. Learned senior counsel for the petitioner has submitted that as the only material against the petitioner connecting him with the 191 kg of ganja is the statement of the co-accused, and as the quantity of ganja seized from his possession is of intermediate quantity, he is entitled to get bail. Any submission?
In fact, that is the only fact, but then the drugs were recovered 50 meters from his house, that's a Pichari, and it was recovered,
But it was intermediate.
but it was intermediate.
Learned counsel, learned additional public prosecutor submits that the trial is at initial stage and charges are yet to be framed. And considering the fact
Although-
that
Although co-accused statement is a weak piece, but then actual drugs were recovered, although it is of intermediate quantity. This will be my submission.
she also submits that even if the statement of co-accused is not taken into consideration, the drugs were in fact recovered from the possession of the present petitioner, though it is of intermediate quantity. I have considered the submissions made by learned counsel for both these sides and have perused the materials available on record. It appears that there were two seizures made in this case. The first seizure was made on 12/4/2023, wherein 191 kgs, 191 point kgs of ganja were recovered. And the second seizure was made from the premises of the present petitioner, where only 12.310 kgs of ganja was recovered. It also appears from record that the only incriminating materials implicating the present petitioner is the statement of Royal Uddin, within bracket co-accused, which was recorded during the course of investigation. It is no longer res integra that the statement of co-accused recorded under section 67 of the NDPS Act is inadmissible in evidence against the same has been clarified by the Apex Court's judgment in the case of Tufan Singh versus State of Tamil Nadu, reported in so and so. The citation to Sunday. As it appears that the quantity of ganja seized from present petitioner is of intermediate quantity. The Embargo of section 20, embargo of section 37 would not be applicable in the case of the present petition. Hence, this court is of considered opinion that the petitioner is entitled to get bail in this case. For reasons mentioned herein above, the above named petitioner is allowed to go on bail of ₹50,000 with one surety of like amount, subject to the satisfaction of the learned special judge Karimganj, with following conditions. Trial or conditions, with following conditions. It is hereby made clear that the observations made herein above in this order shall be limited for, were made only for consideration of the bail application filed by the present petitioner, and it shall have no bearing in the trial which is pending against the present petitioner before the trial court. With above observation, this bail application is hereby dispersed.
A special judge appointments.
Special judge.
Bail application.
Lordship, for 39 application, my lord, the petitioners were arrested on 31/5/2024. And there were 25 days in custody, my lord. FIR, my lord, may be seen at page 8.
25 days. CD is there.
CD is there, man.
Now, my lord, the allegation is that some unknown thieves, my lord, has stolen cows, one cow from the informant and other 3 cows from the other co-villagers. And on the next day, my lord, when the petitioners were coming from Bongaigaon, after completing their
Yes.
my lord. FIR lodged on 35, my lord. On the next day, when the petitioners were coming from Bongaigaon to their home, after completing their hired trip, my lord, along with 2 vehicles, on suspicion, police have arrested the petitioners, my lord. The forwarding report, my lord, kindly see page 15.
Page 15.
15. Last page. So, my lord, 2 vehicles were seized, my lord, from the possession of the petitioners. Now, both the, my lord, tracks, my lord, were owned by the petitioner number 1 and 2. And other petitioners, they are the laborers of
How
petitioner
many
number 1.
petitioners are there in
5
this?
petitioners.
Okay.
From 3 to 5, my lord, they are the laborers. And 1 and 2, they are the owners of those 2 tracks. My lord, nothing was recovered from the vehicle, only on the basis of suspicion, they have arrested.
No, in the vehicle, no cattle was recovered.
No cattle was recovered.
Then why you were? Yes, Mr. Kaushik.
Because, my lord, the Ghulam Usmani, who is the petitioner number 1, earlier there was a case against him of stealing, my lord, cattle. And that is the ground, my lord. And those
Preparing to
vehicles,
steal.
they were coming together, my lord, from Bongaigaon to Ovaivuli. That is the only suspicion. ground, my lord.
Only kettles were recovered, considering their length of detention.
Kettles were recovered.
Recovered.
From where?
Well, that is,
Okay,
I'm
okay.
searching, actually, this CD was gone through by Mr. Gogoi.
Heard,
He was not well today.
What is
M. Ali.
M.
Otherwise
Ahmed
recovered, my lord.
Ali.
M. Ali, learned counsel for the petitioner. Also heard Mr. R. R. Kaushik, learned additional public prosecutor. this application under section 439 of the Code of Criminal Procedure over 1973 has been filed by the petitioners number 1, 2, 3, 4, and 5, or who are who are detained behind the bars since 31/5/2024 within bracket for last 25 days in connection with Bongaigaon PS case number 196/2024. The gist of accusation in this case is that on 30/5/2024, one Prakash Jojo had lodged an FIR before the officer in charge of Bongaigaon Police Station, inter alia, alleging that on 28/5/2024 at night, someone has stolen one cow from his cow shed and 4 more cows from the co-villagers. Stop. Learned counsel for the petitioner has submitted that the petitioners are not named in the FIR. They were, while they were apprehended, while they were returning back from
Bongaigaon town to Abhaipuri, madam.
from
After,
Bongaigaon town to Abhaipuri. After what?
after completing their hire trip, madam, the vehicles,
Trip. In the two vehicles,
two vehicles.
in vehicle bearing registration number AS19AC 5141 and AS18AC 5331. It is submitted by learned counsel for the petitioner that the petitioner number 1 and 2 are the owners of the said vehicles respectively, and the other petitioners are the laborers, and they were apprehended merely on the basis of the basis of suspicion. On the other hand, learned additional public prosecutor has produced the case diary of Bongaigaon PS case number 196/2024 and has submitted that the stolen cattle were already recovered. Stolen cattle have been recovered and the investigation has fairly progressed. Considering the submissions made by learned counsel for the learned additional public prosecutor, this court is, as well as considering the materials available before this court, including the case diary of Bongaigaon PS case number 196/2024. This court is of considered opinion that further custodial detention of the above named petitioner may not be necessary for fair completion of the investigation of Bongaigaon PS case number 196/2024. Stop. Hence, all the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the Chief Judicial Magistrate Bongaigaon with following conditions. Condition number 1 and 2. Send back the case diary. This bail application is accordingly dispensed. I am taking a short break.
Separate page 10 your loss.
Yes, submitted.
Yeah, sheet submitted.
Wait, this lordship, I am for the informant lordship. Today I filed wakalat number.
You are opposing.
Informant for.
Will you oppose?
Yeah, no lordship. Actually, today they have filed one affidavit lordship regarding this case.
Matlab, which are already in the record, my lordship.
But charge sheet has been laid. You may pray before the trial court. You appear before the
Daughter
trial.
went to their relative house lordship.
Or daughter,
Yes, lordship.
not with the informant.
Informant daughters went
Not with the
petitioner, my lord.
And-
Relative house, lordship.
And the
And
allegations,
mistakenly, they have filed FIR, lordship, against the boy because they fall in love each other. That's why.
My lordship, what happened in the case, my lordship? Petitioner was not in love that girl, my lordship. She went to another relative's house and under the misunderstanding, my lordship.
POCSO is there, my lord.
POCSO is there.
Hence, my lord, 326, 307, 120B and
CD would be required,
then they added 10, but these two are villager, my lord.
but case diary would be required.
But they are, my lord, in the poverty report, only allegation is that somebody from village call in phone number, mobile number of this petitioner, and they, my lord, provide the route from village to cross the border.
Okay, heard Mr. B. Borua, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor, who praised for some more time for producing the case diary along with the injury report. When?
My lord, may I pray a vacation code, my lord. My second, my lord, 3rd of July, my lord.
Let this case be listed again on 3rd of July.
My lord, one more thing, my lord, may I point out, my lord, from page 59, in the court below, when they prayed for bail,
No, point out before vacation code.
yes, the CD was not called repeatedly, they did not produce, my lord.
Okay,
Court has observed, my lord, that. Therefore, my lord, your lordship may direct them to positively produce the CD.
let us see.
Right.
Mr. Kaushik will produce the case diary.
On
On
3rd of
3rd.
July. Publish.
Here also CD not received, my lord.
Already 44 days is over, lordship.
What is the offense?
Offense is under 66B, E and 67A. 66B and 66E are bailable, 67A is non-bailable. And 387 doesn't attract lordship, as per the allegation made in the FIR.
And-
FIR at page 10,
Case diary would be required.
on second line, lordship, the vacation progress, from Gorshuk PS. lordship.
It depends on prosecution side.
My lord, on 3rd.
Heard Mr. S. Dekar, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor, who praised for some more time for producing the case diary. Prayer is allowed. Let this case be listed again on
Yes.
3rd of July for case diary.
Apply.
Wait, please, lordship. Lordship, I have been languishing in jail for 557 days till today. That is 1 year, 6 months, 17 days, lordship. So the two vehicles were seized by the police. One was truck of Haryana and another was Hyundai car of Assam's registration. I am a driver by profession, and I was driving the Hyundai Venue following the truck and carrying 1150 kgs by my Hyundai Venue car is not possible, lordship. And I have been falsely implicated.
No, what is the allegation? In your car you were carrying or in the truck?
No, nothing specific. No specific allegation.
What is the seasonally, what seasonally says?
Seasonally says that the contrabands have been seized, but whether it's from truck or whether it's from Venue car, it's not mentioned anywhere. No specific allegations here.
You can see at
So-
page 14, 60 numbers of packets weighing 1050 kg, and 2 is Tata truck and 3 is Venue car.
No, but seasonally specifically mentioned what has been seized from what?
This is not clear. I also
not
couldn't
mentioned.
find out.
This will cause the prosecution.
This is what, and then wrapped in
And what else your submission?
Yeah. I don't have any criminal history. Therefore, this allegation. Hence, I may be exempted from section 7 on the ground of absence of criminal antecedents. And I will buttress my submission with the case of Rajuram plus and Ravi Prakash case.
You have completed 1 year, 6 months. And have you seen this criminal antecedent?
Criminal antecedents, I don't find any of this Yuribu, who is the driver.
My next submission is, Your Lordship, that 2 witnesses have been examined till today.
Out of?
6 witnesses.
Out
The
of
the last witness was examined on 14th of December 2023. And after that, no development in the trial procedure.
When the charge sheet was laid,
charge sheet was laid on
Charge-
16/12/22. No,
29th of April.
no, 29th
29th of
April
2023,
23.
Lordship.
and when charges were framed,
Charges were framed on, yes, 29/9/23. 29/9/23.
okay, heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner R. Yaruibo, Yaruibo, who has been detained behind the bars since 17/12/2022, within bracket for more than for last 1 year, 6 months and 17 days, in connection with special NDPS case number 42/2023, corresponding to Lumding PS case number 201/2022, under section 20B2C/29 of the NDPS Act, which is pending before the Court of Learned Special Judge Hojai. The gist of accusation in this case is that on 16/12/2022, one Jagadish Rabha, SI of police, had lodged an FIR before the officer in charge of Lumding Police Station, inter alia, alleging that on receipt of an information through reliable sources that some huge quantity of drugs are being carried in 2 vehicles from Dima Hasao towards Lumding, and a Naka checking was conducted near National Highway number 27, at National Highway numbers 27, near 2nd APTF stop. At about 7:25 PM, now during Naka checking, 2 vehicles were intercepted, namely RC HR 38A2522 within bracket Tata 4x4 truck, and a Hyundai Venue car bearing registration number AS 11 R 4404 and During search of the said vehicle, 1,150 kgs of suspected ganja was recovered therefrom, and the driver and passengers of the said vehicles were apprehended. On receipt of the said FIR, Lumding PS case number 201/22 was registered and investigation was initiated. Ultimately, on completion of investigation, charge sheet was laid on 29/4/2023 against the present petitioner and other co-accused persons. Learned counsel for the petitioner has submitted that the petitioner was driving the Hyundai car which was seized in this connection and is no way involved in this, in the offense alleged in the FIR. It is also submitted by learned counsel for the petitioner that the seizure list prepared by the seizing officer does not specify as to from which vehicle what quantity of ganja was recovered. Learned counsel for the petitioner has also submitted that though the charges were framed against the present petitioner and the other co-accused on 29/9/2023, however, till date, out of 6 listed witness, out of 6 prosecution witness listed in the charge sheet, only 2 have been examined. And even after prolonged incarceration of 1 year, 6 months, 17 days undergone by the present petitioner, the trial has not fairly progressed. And there is no hope of early culmination of trial. Learned counsel for the petitioner has also submitted that the petitioner has no criminal antecedents and he has been falsely implicated in this case. He has cited a ruling of Apex Court of India in the case of Rajuram versus State of Bihar, reported in 2023 0 Supreme within bracket SC 80, wherein the petitioner was given benefit of having no criminal antecedent and was allowed to go on bail in a case involving commercial quantity of ganja and commercial quantity of contraband. Now, for prolonged incarceration, which cases you are relying?
Muhammad Muslim.
Learned counsel for the petitioner has submitted that though in the present case there is seizure of commercial quantity of ganja, however, as the detention of the present petitioner is long enough and as the trial has not fairly progressed, he is entitled to get bail on the ground of prolonged incarceration only. It is submitted that as that prolonged incarceration
Muhammad Muslim, it was 7 years, no?
Then Chitta Vishwas is squarely covering my case. Chitta Vishwas was also enlarged on bail 1 year, 6 months, 17 days, and my period is also exactly same.
Justice Surana.
Chitta Biswas versus State of West Bengal.
That's
I'll
it.
provide.
As there is an inordinate, he also submits that as there is an inordinate delay in culmination of trial, the embargo under section 37 of the NDPS Act 1985 gives way to the fundamental right of the accused guaranteed under Article 21 of the Constitution of India. What is your solution?
In fact, here what had happened is in the charge sheet or in
Commercial
the
quantity is involved.
commercial quantity, and it is said it is recovered from both the vehicles. What happened? It was night time. There was not sufficient light, so they had taken it to the police station, and then perhaps it
Learned
was
Additional public prosecutor has submitted.
Search was not made in the
Has
place
oppo-
of occurrence.
because it was
opposed
night
Yeah.
time, no
grant
sufficient
of
light.
bail to the present petitioner on the ground that commercial quantity of contraband has been seized in this case, and therefore the embargo of section 37 is applicable to this case. I have considered the submissions made by learned counsel for both the sides and have perused the scan copy of the case record of special NDPS case number 42 within bracket H/2023, which was called for in connection with this case.
Oh, sorry. Ravi Prakash to क्या काटेगा? It is a Nazif to the Nazif to there was only.
Paragraphs, I will not repeat them. What paragraphs are to be repeated? I have heard.
This is on.
It appears from the record available before this court that the petitioner was arrested on 17/12/2022. And though charges were framed on 29/9/2023, till date, only 2 of the 6 listed witnesses have been examined. Code para 17, para 18, para 19, 20, 22, 24. In the instant case also, the petitioner has been detained behind the bars for last more than 1 year, 6 months. And the trial is yet to culminate. Stop. In view of the facts and circumstances of this case, as well as in the light of observation made by the apex court in the ruling cited herein above, wherein the apex court had dealt with the question of prolonged incarceration of similarly situated petitioners who were before the apex court, this court is of considered opinion that in the instant case also, the facts and circumstances are such that the detention undergone by the petitioner may be considered to be long enough to outweigh the embargo of section 37 of the NDPS Act 1985. Stop. Hence, the petitioner is entitled to get bail on the ground of prolonged incarceration only. In view of above fact, in view of above, The above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount. To the satisfaction. Where do you reside?
Manipur.
What is
Yes, East Imphal.
Say, Imphal.
what is the assurance that you will
Local surety.
two sureties?
Local surety.
Two.
One or two, your lordship.
Okay, two sureties of like amount. One. Like amount, within bracket, one of whom should be the resident should be the resident of the state of Assam, subject to satisfaction of learned special judge Hojai with following conditions from that. Same condition. With above observation, this bail application is hereby disposed of.
Thank you, please.
May I please your lordship, 439 application, charge sheet manner under section 21C, 25, 29 NDPS Act, commercial quantity heroin manner. My only case is that non-compliance of section 42(2).
What was the date of arrest? 9/3/23.
My lord, I was arrested on 11/3. I was taken into custody on 9/3, arrested on 11/3/2023. 1 year, 3 months, 14 days.
You were arrested on 11/3.
11/3/2020.
1 year,
1 year, 3 months, 14 days.
3 months. What is your ground?
Non-compliance of section 42(2).
42.
2 of the NDPS.
42 clause
2.
Within 72 hours.
72 hours.
Have you gone through?
Yes.
It is there.
Yes, madam. Substantial compliance is there.
Okay, then let us hear. Make
Section
us-
42(2). madam. Where an officer takes down any information in writing under subsection 1 or records ground for his belief under the proviso thereto, he
No.
shall
No,
with-
before that, when the seizure was made, how much?
1 kilo,
Just
274 grams,
1 kilo
1274 grams
of
of heroin.
Oh. Yes. On
42(2).
seizure was on 9/3,
On 10/3,
10/3.
midnight.
From where seizure was made?
From a vehicle, my lord, in which I was traveling, a car.
Okay.
It is alleged that it was concealed in the doors,
Concealed in
door,
doors. Okay. Yes.
42(2), I have already read, madam, that he has to send within 72 hours a copy thereof to his immediate official superior. So if I may place the FIR, page 15, madam, for a moment.
Yes,
Page
Mr.
15, the FIR, madam. That with reference to the above, I would like to inform that yesterday, that is 9/3/23, at about 11:40 PM, an information was received from the respected SP Karimganj that one suspected person who was the driver of Maruti Suzuki Alto so-and-so was supposed to traffic a huge quantity of drug concealed in his vehicle from Mizoram towards Assam. Accordingly, the information was recorded by Nagra PPGDE number 99 dated 9/3/23. And I have instructed to carrying out the operation with my accompanied staff. Accordingly, I have informed Inspector Deepak Das, CI so-and-so, about the matter over phone. The lordship will mark this, over phone he was informed. And he was duly authorized me as per provision of section 42 NDPS Act. And along with my team left to conduct a NACA checking point in front of so-and-so at 1:30 AM. Almost after 1 hour, 40 minutes or something. This is also recorded by Nagra PP JDA number 100 of dated 10/3/2023. The drug seizure kit comprising of laptop, envelopes, weighing machine, etc. was made ready. The party comprising me, so and so, staff left for conducting Naka checking in front of Kanakpur Masjid. I'll stop here for a moment.
Yes.
So what he is saying is that compliance of section 42 was done when he informed his senior officer over telephone. I checked the scanned copy, madam. In all the papers, it is said that he has informed over telephone. There is no written report given to the senior officer.
Okay.
So he has been authorized. The authorization letter is there. But the authorization letter itself says that it was issued at 11:40 PM. The moment he received the information, where was the time to inform his senior officer, and the senior officer at the same time gave him the authorization. And then he waited for 1.5 hours in the police station, preparing all this, waited for the authorization letter to come to him. But he not even in any place he has stated that I had sent the report as a copy of the information that I had received to my superior. There is nothing on that.
Where he took down the information in writing? GD entry has been.
GD entry has been there 99. The time that is recorded against GD entry is 11.
Now what is required under law?
Under law, the GD entry that he has received or he has recorded.
Copy of that should
have been sent
to the
superior officer
within 72 hours.
within 72 hours, not immediately, within 72 hours. It is a mandatory provision. It has to be.
Any other ground?
No matter.
Only
I'm not
this.
taking.
But first of all, my learned friend has taken the ground of violation of section 52. But I have not found anything regarding that in his petition. Madam.
Okay. You have
No,
not
sir.
pleaded that ground.
Not in specific terms. If lordship permits me, I'll file it by tomorrow. Today it's no time. Day after tomorrow, it can come up. I can file an additional affidavit. Taking this.
Okay, let him file additional affidavit.
And so far, my lord,
Then we'll hear him after vacation.
my lord,
Or in the vacation. Group.
and after vacation.
After vacation.
No,
Already.
let your grounds be on record.
I'll bring it on record by tomorrow. Tomorrow
And
morning.
in
I
the
can file.
meanwhile, you find out from the case diary, is there any communication to?
My lord, I have already found out, my lord, there is communication that my learned friend already stated.
Lordship can peruse that.
So I have already marked that portion also. My lord, why? Because at that time, these Naka, because your lordship have to appreciate that information is regarding movement of a car. Supreme Court has, taken out decision has stated that.
No, we
substantial
will
compliance-
examine this issue
Yes, my lord.
because this is otherwise commercial quantity of contraband.
Commercial.
You are otherwise behind the bar.
And so far, my lord, delay portion is concerned with.
I'm not.
Yes, my lord. They have already taken so many time in the court below.
They will not get benefit.
Yes.
I'm not taking.
On request of heard Mr. B. Prasad, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor. Learned and the counsel for the petitioner has prayed for allowing the petitioner to file an additional affidavit to bring on record certain facts / grounds which grounds for seeking bail by the petitioner. The prayer is allowed. let this matter be listed on 17 July 2024.
Can it be on 22nd?
22nd, let it be on 22nd July 2024. The petitioner may file his additional affidavit before the next date of hearing. List accordingly.
Item 61. Wait, Mr. Lordship. This search case file is going on, LCR is before your lordship. It's a POXO case I'm behind.
What is the offense?
Offense,
Of
commercial quantity, my lord,
commercial quantity.
commercial quantity, my lord.
You are suffering from cancer.
I'm cancer patient.
Any,
And the document, my lord, in my petitions, besides my petitions, my lord, medical authority has also sent the documents, my lord.
but case diary would be required.
Required, madam, and one report from jail authority, ma'am.
Charge sheet has not been laid.
On the last occasion, if I rightly recall, my lord, my learned friend was saying it was prepared, my lord, but not submitted yet.
Okay.
My,
Can it be fixed on Friday, my lord?
Friday.
Friday.
Let it be on Friday. He is suffering from
my record is page 20, my lord, and the medical reports sent from the jail authority, my lord. Otherwise, based on only on 67 statement, I was picked up, my lord, page 16. I'm not on merit at this stage, my lord. Considering my medical condition, my lord, I'll wait till Friday, my lord, but definitely on Friday, my lord. This is for interim bail, my lord. Till pendency of this, only on medical ground.
case diary was not called for.
Case diary was there, on the last listed was on 19th, my lord. You can go to this.
This is only.
You can go to this.
Oh, trying to fix full almost silent.
You will produce case diary by Friday.
My lord.
Otherwise, we will consider your prayer only.
I'm obliged.
Heard Mr. A.S. Tapadar, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor. In this case, the petitioner has also filed. This interlocutory application is for interim bail.
Interim bail.
No, before that. In main case, the learned additional public prosecutor has prayed for some more time for producing the case diary. The prayer is allowed. Let this case be listed again on 28/6/2024. In interlocutory application, you filed. This interlocutory application has been filed by the petitioner in connection with bail application number 1292/2024, praying for grant of interim bail to the petitioner on medical grounds, as the petitioner is suffering from cancer. Learned additional public prosecutor submits that he will produce the case diary by Friday, and therefore this interlocutory petition may be considered on that day. Prayer is allowed. Let this matter be also listed on 28/6/2024, along with bail application number 1292/2024.
I'll do bail. Anything else, sir? My lord, this case is handled by Mr. B.B. Gogoi, additional PP. Today he suddenly falls sick, my lord. Can it be fixed on day after tomorrow, my lord?
B.B. Gogoi.
B.B. Gogoi.
What is the matter?
So, Madam.
Day after tomorrow.
Day after tomorrow. It will be retained, my lord.
On request of learned counsel for the heard Mr. B. Bora,
D. Boram.
D. Bora, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor, as well as Ms. M. K. Brown, learned amicus curiae, representing the first representing the informant. Mr. R. Kaushik submits that this case is looked after by another additional public prosecutor, namely Mr. B.B. Gogoi, who is indisposed today, and therefore prays for fixing this case on 27/6/2024. The prayer is allowed. Let this matter be listed accordingly on 27/6.
Item 64 and item number 48.
My lord, the matter may be adjourned for the day, my lord. My senior is not well.
When after vacation,
No, my lord, day after tomorrow.
day after tomorrow, heard Mr. What is your name? What is your name?
A. Iqbal, lord.
Heard Mr. A. Iqbal, learned counsel for the petitioner, who prays for an adjournment on the ground that the conducting counsel, Mr. S. Sheikh Hassan Mohammed, is indisposed. Considering the ground, the prayer is allowed. Let this matter be listed again on 27/6/24.
I am inquiring for respondent number 2.
Also heard Mr.
K is Khandakar.
K.H. Khandakar appearing for respondent number 2. Day after tomorrow,
I have not received the copy only.
you
I
give a
received
copy of
the-
today itself you give.
Ma'am,
They will give in
my
both the
lord,
case.
48.
48.
48 same order. They will give copy today.
Lordship, I am for the 48.
Not in
Not in 63. I am for 48.
in 48. देखा पड़ता है फिर.
Item 46. Item number 46.
None appears for the petitioner on call. List this matter on 15/7/2024.
The excise case. I need to second one.
Item 47. May it please your lordship, this is the 438 bail application.
Yes, there is
Nothing like-
No.
No, my lord. Today also she did not receive it.
case diary would be required. Yes, what to do
Friday, my lord.
after vacation.
Long time, your lordship, the case is pending, so may I pray on Friday? We'll take a chance, your lordship, if at all.
You are on interim.
No, I am not on interim. your
You are
lordship.
not on interim.
No, your lordship.
What is the offense?
Offense, your lordship, may kindly peruse your page 13, your lordship, the FIR. Page 14, relevant part starts, your lordship. There is an allegation that I am trying to convert people from one religion to another religion.
No, let us give them interim
Yes, sir.
because it is pending for case diary since
Yes, my lord, several occasions. my lord.
several occasions.
Yes. My lord, CD, actually 2-3 times CD was there, then it was returned back for updation. Then it was called for, then it didn't came, my lord.
When the last time case diary was available?
My lord, last, it
10/5.
was
Okay.
10/5, my lord, yes. Perhaps on 21/5 also CD was there. No.
But since December, you are not arrested.
No, your lordship.
I apprehend that I may be arrested, Your Lordship. If protection is granted, I will be highly obliged, Your Lordship.
When will you bring the CD?
Friday, my lord.
Will it be possible?
We'll try, my lord. I'll personally call, my lord.
Okay. Heard Mr. T. Deori, learned counsel for the petitioner, also heard Mr. R. Kaushik, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed on 28/6/24 for case diary.
I'm deeply obliged.
Maybe not. My lord, in this case, my lord, the secretary, my lord, and the president of my lord, Somavai Somiti, my lord, misappropriated, my lord, the PGS rights, lordship. My lord, on the day of my lord, the retirement, lordship, the secretary, my lord, to save his skin, lordship, submitted an application before the deputy commissioner that there is a shortfall of rights and blamed the, my lord, the members of the, my lord, Somavai Somiti, lordship. And on that basis, lordship, FIR was lodged. Kindly see the FIR as page 10, lordship.
Case diary is there.
Yes, my lord.
Kindly see the FIR is at page 10. My lord, 12 is the operative part, lordship. My lord, five members were, my lord, blamed, my lord, out of 5, my lord, 4 were arrested, my lord, immediately after 4, 5, no? Get him separated.
Now, what is the allegations?
My
There
lord.
are. Yes, yes.
My lord, page 12, lordship. Overall,
I will ask questions.
My lord. Actually, I don't want to.
my
read
lord,
it out.
4 out of 5 lordship were, my lord, released by the learned magistrate lordship under section 437 lordship. Now, my lord, only one, my lord, the petitioner remains lordship before your lordship for third, my lord, granting bail under section 438 CRPC lordship.
Oh, 4 of the petitioner's name is
My lord, Inamul Haq lordship.
number 5.
Yes, lordship. Other 4, my lord, were arrested lordship immediately after lodging the affair, my lord, and then, my lord, immediately they were released by the learned magistrate lordship.
Where is the
The bail order, kindly
bail
see, lordship, that order is at page, lordship, as 29, lordship. Sorry, yes. Judicial magistrate first class lordship. Within a short time, they were released, lordship.
For how long they were detained?
They were arrested on 21/2/2022, lordship. On 6/3, my lord, they were released, lordship, after 13 days, lordship. Now, my lord, secretary is the responsible for any, my lord, misappropriation, lordship. The go down, keys of the go down, everything is, my lord, with him, lordship. The members, lordship, what I'm submitting.
Yes, what is there in
My
the
lord,
case?
kindly peruse page 33, my lord.
What is there?
My lord, the lower court rejected this bail application by considering the case diary, my lord.
That is 438, lordship.
Yes, my lord. And this is also 438.
Page number?
Page 33, my lord.
Yes, I have annexed that. That is, I am before you, lordship.
And CD also, my lord, there are independent witnesses who, apart from the committee members, my lord, this person, including the arrested person who were released on bail, my lord, they take away, my lord, rice forcefully, which are meant for the school students, my lord. Now they are facing problem to distribute the same, my lord.
My lord, before going to that lordship, kindly see the, my lord, page 15, lordship. A resolution was, my lord, this matter was discussed in the, my lord, board of directors, lordship meeting. That is, kindly see at page 15, lordship, that resolution. Prior to the FIR was lodged on 22/2024. My lord, the board of directors meeting was on 27/1/2024. That is at page 15, kindly see lordship. Lordship annexure 2.
What is this?
This is, my lord, this is a resolution, my lord. In the board of meeting, directors meeting, the matter was discussed, lordship. Kindly see the resolution number 1, lordship. May I read, lordship?
Yes, yes.
Today in this meeting, an order number.
Your name is Abdul Malik.
Abdul Malik is the secretary, lordship. That is the, my lord, that is the fact, lordship. The secretary, my lord, at the powers of retirement, lordship, he failed to explain why the, my lord, there was shortfall of 27 quintals of, my lord. He is answerable, my lord. To save his skin, lordship, he submitted application before the DC, my lord, saying that there is shortfall, my lord, the members have, my lord, misappropriated, my lord. Is it believable, lordship? What is the rule of members? Members have, my lord, members, the rule of the members, my lord, is to attend the meeting, discuss the matter, lordship.
What is the progress otherwise?
My lord, progress, my lord, they are taking down the statement of independent witnesses, my lord, and he is absconding, my lord, till now.
Let him appear.
Otherwise, my lord, there are specific materials I can see.
Grounds, incriminating materials are there.
Yes, my lord. Independent witnesses versions are also there, my lord.
But his detention may not be necessary.
My lord, because he is doing this from last couple of years, my lord.
Oh, no. The accused number 1 has, my lord, subsequently been, my lord, selected as the president, my lord, of the, my lord, Samabhay Samiti, my lord.
That is a different thing.
Everything is going okay, lordship. Because, my lord, this is the secretary, lordship, to save his skin, my lord, it is done, my lord. The president, my lord, earlier president also is on board, lordship. My lord, the license was, PDS license was, my lord, got rejected, lordship, sorry, cancelled, suspended, lordship. The president, my lord.
Yes, yes. Continue.
My lord, the president's son was given, my lord, sons, my lord, to, my lord, leave the rights, PDS rights from the go down, lordship. And that was challenged by the present petitioner, my lord. Kindly see the writ petition, lordship. My lord, that writ petition is at page, lordship, 22, lordship.
Heard Mr.
M.H.
Ahmed, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Inamul Haq, who is apprehending his arrest in connection with Moirabari PS case number 29/2024 under section 120B/420/406/409/34 of the Indian Penal Code, read with section 7 of the Essential Commodities Act 1955. The gist of accusation is that the petitioner that on 22/2024, one Rupam Bayan, inspector of he's inspector of FPD and CA, Morigaon. Before
Food
the
and Civil Supply Inspector.
Food and Civil Supply, okay, FPD and CA, Morigaon. Before the officer in charge of Moirabari Police Station, inter alia, alleging that 5 executive members of Messrs. Doloigaon Samabhay Samiti Limited have illegally and unauthorizedly diverted the MDM rice from GPS's godown into the black market for illegal monetary gain. On receipt of the said FIR, Moirabari PS case number 29/24 was registered. Learned counsel for the petitioner has submitted that the allegations made against the present petitioner in the FIR are not true. It is also submitted by learned counsel for the petitioner that out of the five accused persons named in the FIR, including the present petitioner, 4 of them were already granted bail by the Court of Learned Judicial Magistrate First Class, Morigaon on 6/3/2024 in bail petition number 137/2024. Learned counsel for the petitioner has also submitted that though the Court of Learned Assistant Session Judge Morigaon had rejected the anticipatory bail application preferred by the present petitioner by his order dated 21/3/2024, passed in bail application number 109/2024 on the ground of seriousness of the offense involved and the ramification and its wide ramification in the society. However, he submits that the petitioner is, however, he submits that as the arrested accused persons are already released on bail and as he is ready to cooperate in the investigation, he may be allowed to go on bail and go on anticipatory bail. On the other hand, learned additional public prosecutor has produced the case diary of Moirabari PS case number 29/2024 and has submitted that there are sufficient incriminating material against the present petitioner in the case diary. He has also submitted that otherwise the investigation has fairly progressed. However, the statement of present petitioner is yet to be recorded. I have considered the submissions made by learned counsel for the both the sides and have perused the case diary of Moirabari PS case number 29/2024. It appears that there are some incriminating material against the present petitioner. However, considering the fact that the investigation has fairly progressed and all the other co-accused persons who were earlier arrested have already been granted bail, if the petitioner cooperates in the investigation, his custodial detention may not be necessary for fair completion of the investigation of Moirabari PS case number 29/24. Stop. Hence, the above named petitioner is hereby directed to appear before the investigating officer of Moirabari PS case number 29/24 within 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with Moirabari PS case number 29/2024, the above named petitioner shall be allowed to go on bail of rupees 30,000, rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority, subject to following conditions. Condition number 1 and 2. With above observation, his bail application is disposed of. Send back the case study.
Master lawyers.
39 CD not received.
My lord, Lordship, I have entered appearance on behalf of the informant, Lordship.
Oxo case.
No, Lordship, informant has entered appearance to file objection. Lordship. He is on interim, Lordship.
I am on interim. I have appeared before the IO on 17th.
You have a, okay.
Lordship, I'll file objection.
Heard, Mr. What is your name?
M. R. Sodiol.
M.
R. Sodiol.
M. R. Sodiol, learned counsel for the petitioner. Also heard Mr. R. R. Kaushik, learned additional public prosecutor, who submits that case diary has not been received and prays for some more time for producing the case diary. On the other hand, Mr. D. Deka.
D. Das.
D. Das has submitted that he is appearing on behalf of the informant and intends to file an objection against making the interim anticipatory bail granted to the petitioner absolute.
Yes.
The prayer is allowed. The petitioner may file, the informant may file his written objection before the next date. Let a reminder be issued for case diary. Let this case be listed again on 22nd July. 26th July. The interim order shall continue till next day.
Deeply obliged.
Item 40 and item 57.
Price CD not received. My lord.
Lord, actually, item 40, that person was in interim and he appeared before the IO. And item, so far as item 57 is concerned, my lord, his lordship fixed it to the along with that matter. In that case, no interim.
In case.
Item 40, my lord, after perusing the case diary.
In 40.
Yes, 40.
Heard Mr. J. Ahmed, learned counsel for the petitioner. Also heard Mr. R. R. Kaushik, who prays for some more time for producing the case diary. What is the offense?
Offense is 376. We never get
376.
With the offense, my lord. My submission, my lord, I have narrated in case 4, my lord, paragraph 5, my lord.
What is your name?
My name, my lord, Mulluk Hussain, alias Bappi, my lord.
Mukul Hussain.
Mukul Hussain.
But there are specific allegations against you.
My lord, the containers are recovered from the house campus, my lord, not the houses, my lord.
What is the?
Recovered from his house, my lord.
House campus, my lord, actually, my lord.
That is his house, my lord.
House campus.
What was recovered?
6 containers, my lord, containing 6 gram heroin, suspected heroin, my lord.
FSL is not received yet, my lord.
My lord, I am not,
FSL received, my lord, heroin.
I am not connected in any way, my lord. This is a total conspiracy, my lord. Transferred by one Ayubali, my lord. He is a Periwala, my lord, who always used to visit the house of the petitioner, my lord. Which was complained by the petitioner wife as well as by the petitioner, my lord.
Recovered from his house, my lord. Sija witnesses also supported that. That is a AV man.
This is the first incident, my lord.
No. What, 6 containers containing how much heroin?
6 gram.
Intermediate quantity.
Yes. More than 5 grams. You surrender before the IO.
My lord, at any condition, my lord, may be allowed, my lord.
Oh, heard, Mr.
Exert Sheikh, my lord.
S.Z. Sheikh, learned counsel for the petitioner, also Mr. R.R. Kaushik, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure from 1973 has been filed by the petitioner Mukul Hussain alias Bappi, who is apprehending his arrest in connection with Bilasipara PS case number 6/2024 under section 21B of NDPS Act, 1985. The accusation against the present petitioner is that on 9/1/2024, on 9/1/2024, one FIR was lodged by one Ranaditya Doloi of Bilasipara Police Station from my inter area alleging that from which place it
From his house, that is only mentioned, my lord.
Actually, my
And
lord,
the Seja
house
witnesses
campus, my lord.
That is his version, my lord. And Seja witnesses also stated that from his house, my lord.
from the house of the petitioner. Six small size container containing suspected heroin were recovered. Learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case. It is also submitted by learned counsel for the petitioner that the containers containing contraband were not recovered from his house, but from within his house campus. And same were planted by one Ayub Ali. By whom?
My lord, one ferriola, my lord. He is the local ferriola, my lord.
One rag picker. Stop. And hence, he may be allowed to. He has also submitted that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Bilasipara PS case number 6/2024 and has submitted that there are materials in the case diary showing that the petitioner is involved in the offense alleged against him in the FIR, and the seized contraband was recovered from his house. And there are independent Caesar witness to prove the said facts. So I have considered the submissions made by learned counsel for both the sides and have also perused the materials available on record, including the case diary of Bilasipara PS case number 6/2024. On perusal of the case diary, it appears that there are incriminating materials against the present petitioner available therein, which does not justify grant of a favorable order in to the petitioner under section 438 of the Code of Criminal Procedures 1973. Hence, the prayer for anticipatory bail is hereby rejected. Send back the case.
Pursuant to the interim order, he appeared and recorded his statement.
Heard Mr. I.U. Chaudhary, learned counsel for the petitioner, also heard Mr. R.R. Kaushik, learned additional public prosecutor, who submits that the petitioner was granted interim anticipatory bail by order dated 3/6/2024 with certain conditions. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer, and his statement under section 1616 of the Code of Criminal Procedure has also been recorded. In view of the fact that the petitioner has cooperated in the investigation and has complied with the directions of this court, the interim anticipatory bail granted to the above named petitioner by order dated 3/6/2024 is hereby made absolute with condition numbers 1 to 3 attached to the said order remaining intact. This anticipatory bail application is accordingly disposed of.
May I please, Your Lordship?
44 CD not received.
My Lord, this is the second day that the CD has not arrived, my Lord. Today I'm pressing for an interim, I'm not on interim, my Lord. Lordship may kindly come to page 17, that's the FIR. There are two petitioners, husband and wife. May I read it, my Lord?
What is the allegation?
The allegation is that we have taken money from the informant and we have not returned. My Lord, and through bank, through the ATM of our husband, late husband. So, my Lord, if presuming for a while it is true, these are all documentary evidence, my Lord. Why our custody is required? If an interim is granted, my Lord, we'll go and cooperate with the investigation, my Lord.
Okay, heard Mr.
J. Boga.
J. Bora, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor, who submits that the case diary which was called for has not arrived and prays for some more time for producing the case diary. On the other hand, learned additional public prosecutor has, on the other hand, learned counsel for the petitioner has submitted that this is for the second occasion the prosecution has failed to produce the case diary, and the petitioners, who are husband and wife, are not on any interim bail. It is also submitted by learned counsel for the petitioner that on 15/5/2024, one Mrs. Rupali Sharma Borua had lodged an FIR against the present petitioner before the officer in charge of Gitanagar Police Station, inter alia stating that when the informant sought help of the accused persons to this 15 lakhs, what is this 15 lakhs?
This 15 lakhs, as per the FIR, she asked us
Sought for help
Help
of rupees
to
15
build a
lakhs.
house.
Then what happened?
My Lord, then she goes on to say that we said that we will arrange for her a loan, and for that her Aadhaar, ATM, all these are required. And using that, we had taken out an amount in the year of 2022, an amount of rupees 5 lakhs. Thereafter, again, she goes on to say, then on February, again, we took out an amount
an amount from her account, 760. So in total, her allegation is that we had taken out an amount of rupees 12,60,000 from her account over a period of 2 years, whereas she was asking help from us for 15 lakhs.
Out of that amount, my lord, 7,60,000, they, this alleged that, my lord, they took out using her late husband's SIM card, my lord.
SIM card. And from a SIM card, presuming I have the SIM card. For that, even I need to know the PIN.
Oh, what was the last name? To the tune of rupees 15 lakhs and the present accused person / petitioners to the tune of rupees 15 lakhs. And she was assured that they will obtain a loan from bank, and for that they took the ATM card, passbook, Aadhaar card and other and the SIM card of her husband's phone, which is linked to the bank. Stop. It is also alleged in the FIR that by using her husband's SIMs, the petitioners withdrew an amount of rupees 5 lakhs and thereafter again withdrew an amount of rupees 7,60,000, and in total it is alleged that they have fraudulently withdrawn an amount of rupees 12,60,000 from the bank from the bank account of the late husband of the informant. Now, what is your submission regarding allegation?
My submission is that we have also returned certain money. We actually were helping her in taking out the money from her account, and we have also returned certain money. My lord, and presuming that this FIR for a while, let us presuming that it is true. Even then, my lord, these are all documentary evidence which the investigating officer can
No, but if you have done wrong, will you get benefit of anticipatory bail?
My lord, that's what I'm saying. My lord, assuming then a charge sheet may be filed against me and I'll go for jail once and for all. Why my custody is required?
Then we have to peruse the case.
That's what I'm saying, my lord. CD will be required. For that, my lord, petitioner number 2 is a government servant working for AACB, my lord, and they have been away from that hold for a while. So I'm praying.
No, but if you have taken money, if you have taken the document.
And for a while, my lord, page 18, where she says that 5 lakhs, it was given by GPay. It was given by her. So there is a certain dispute, my lord, which the case that will reveal.
But your case is not that you have not withdrawn.
My lord. Yes, of course. My case is that I have withdrawn on her instructions.
Okay.
On her instructions.
But you have not given back the money to her.
My lord, there are certain discrepancies which we have been saying to the informant that let's sit, let's talk. And she filed the FIR against us, the husband and wife.
We have to peruse the case, right?
My lord, of course.
No interim now.
My lord, I'm saying, my lord, petition, at least for petitioner number 2, my lord, she is a government servant, my lord.
Okay.
And they have a 2-year-old child.
What was the last name?
And moreover, my lord, this FIR is a belated FIR.
Bank account. Learned counsel for the petitioner has submitted that the petitioner number 2, who is lady, who is a lady and a government servant, and has a 2-year-old minor daughter, minor child, may at least be granted interim bail till arrival of the case diary. Stop. Having heard submissions of learned counsel for both the sides, and considering the facts and circumstances of this case, as well as the fact that the prosecution side has failed to produce the case diary on last two occasions, the petitioner number 2 is granted protection of interim bail till arrival of the case diary. Let the reminder be issued for case diary fixing when
My lord, 17 July.
fixing 17 July for case diary. In the meanwhile, if the petitioner number 2 is arrested in connection with the Itanagar PS case number 10115/2024, she shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1. Let this case be listed on 17 July for case diary.
Item 45.
Petitioner is in the interim, my lord, and petitioner already appeared before the investigating authority, my lord.
He appeared.
Heard Miss S.H.M. Foucault, learned counsel for the petitioner. Also heard Mr. B.B. Also heard Mr. R.R. Kaushik, learned additional public prosecutor, who submits that the petitioner was granted interim bail by this court by order dated 5/6/2024. And in pursuant to the directions of this court,
He
the
appeared on
petitioner has
5/6.
appeared before the investigating officer of Moibong PS case number 21/2023. And his statement has also been recorded under section 161 of the Code of Criminal Procedure, 1973. In view of the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to the above named petitioner. What is the name of petitioner?
Mukul Chandra Bora.
Mr. Mukul, namely Mukul Chandra Bora, is hereby made absolute with conditions attached to the said order remaining intact. With above observation, this bail application is disposed of.
Item 46.
As per the direction of this honorable court lordship.
Well, the 46
we
are still
appeared-
submitted.
We appeared on 7th and our statement has been recorded. If charge sheet is submitted, then my further in detention is no longer warranted, lordship. I'll face the trial.
Heard Mr. A. Bhattacharya, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor, who submits that the charge sheet has been submitted, laid in this case bearing charge sheet number
85/24 dated 17/6/24.
Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by order dated 5/6/2024, and in pursuant to the directions of this court, the petitioner Shrevas Singh has already appeared before the investigating officer and has cooperated in investigation stuff. In view of the submissions made by learned counsel for the petitioner, the interim bail granted to the above named petitioner by order dated 5/6/2024 is hereby made absolute with condition number 2 and 3 attached to the said order remaining intact.
Item 47.
Well, 47, this petition is not maintainable, my lord. Victim is 9 years old girl and 376 AB is there.
Yes, Mr. Rabha, what
My lord. Item number 50, my lord.
tomorrow?
Item number
You are
40.
not on bail.
No, man.
Same with item 65.
Yes, there is also risk. Yes, there is here, my lord.
But there are a lot of cases where still bail is to be granted. If we continue beyond 445,
Madam,
there will be no limit.
Malab,
So somewhere we have to stop.
Malab, in in anticipated bail application where there are interim protection, those can be taken up after vacation also, but where there are no interim protection,
Okay, from tomorrow that we will do that.
because my lord, earlier also we have seen in most
No,
of the
this
court-
suggestion should have come in the morning itself.
because earlier also we have this before vacation where there are
Your
interim-
65 and 55, 65 and 50 we will take up tomorrow. Where there are interim protection.
Can
from
defer it,
tomorrow,
my lord.
We will defer.
My-
We will take
Item
it.
number 49, your lordship, kindly be taken up tomorrow. I have no interim protection. It's an application number 438, your lordship.
Without interim protection, your lordship may fix tomorrow, my lord, and
Okay.
tomorrow main list,
You may make request to the
courtmaster.
courtmaster day after tomorrow. Tomorrow it will be difficult to send
Absolutely.
the file.
The day after tomorrow,
Day after tomorrow,
where there is no interim order.
where there is no interim protection, day after tomorrow, Dinigo. And from tomorrow, we will take up, this is a good suggestion, where there is interim protection, we'll take up,
After vacation.
not after vacation,
After.
and on this, in the second half,
Second.
after taking up other matters.
Absolutely.
My lord, item number 52, 2 days was listed, but not it's due to paucity of time, my lord. Item number 52. Only, my lord, condonance, okay, delay petition was filed, my I application. Kindly fix, my lord, tomorrow or day after tomorrow,
Okay,
day after.
day after tomorrow.
Lordship, regarding item 21, Lordship, that my name is not reflected in the cause list, Lordship, that's why I skipped that item, Lordship. May I pray, Lordship, register me direct to list, reflect my name in item 21. Lordship,
Item
as
number
stated.
21. Item number 21, name of Mr. B. Chaudhary be reflected in the cause list henceforth.
Lordship, let the matter come up, Lordship, on the last day, 28th, Lordship,
After,
because. Because Lordship, it's a bail matter, Lordship, 389 petition is there, Lordship. It's only for 3 years imprisonment, Lordship.
389 may come up on 50 because you have been convicted
Yes,
after vacation.
there is no protection, that's why, Lordship, it's a juvenile, Lordship.
No, after vacation.
Always.